Hi, chat. It's Friday night. I mentioned we were going to get to this on Friday. Yes, and here we are. We are pulling my white privilege card for not being on time. That's okay. CPT time works. CPT time is perfect for YouTube. Also, real quick, who's messaging me? All right, guys. Oh, assholes react. We'll go with this. We'll go with the first one. That's a funny one. All right, guys. So we are going to be covering Rhode v. Bonta. And if you guys didn't know this, in California, obviously the gun laws suck there. And they've sucked there for a really long time. And every year, and basically after every major shooting, they just ratchet things up just a little bit more, a little bit more, a little bit more, a little bit more. They're to the point now where back in 2016, you had to have a permit to buy ammunition, which itself isn't that weird. Well, that is bullshit. Other states have that as a thing, like in Massachusetts, for example, you need a license to purchase ammunition. And it was good for like 4 years. Well, in more recent times, California said, no, we've got a better idea. We're going to make you do a background check every time you go purchase ammunition, which is absolutely fucking insane. So, and also, some of you might think, well, then I'll just buy my ammo online. Can't do that. Can't get out of state ammo. So you're kind of fucked if you live in California more than ever before. It's getting worse and worse and worse. So PC42, Sean, can we have sex? Sir, I noticed that you are of the equine persuasion. You really should be looking to Vosh for that. He will certainly let you have sex with him. I can promise you that. I can promise you that. I love you. I love you too. So, anyways, California has this requirement where you need a background check every time you buy ammunition. Every time. Seller says they don't search you when you drive back from Arizona. That's correct. But if you guys do know, in California, they send police over to Reno, or they will send them to anywhere where there's a gun show over the state line, and they will take note of the license plates of people that are at those events. They're from California. This happens in Pennsylvania. This happens in New York and New Jersey, where people go to Pennsylvania, or any banned state. This is actually a very common thing. So at some point, they're going to start probably hassling people. Give it time. I don't think they want you. I don't think they want to do it, but yeah, it's not good. It's not good. And it's only getting worse for California. That said, though, California does have an advantage. They have the benevolent Roger Benitez, Saint Benitez of San Diego. He presides down there in federal court, and district court down there for the Southern District of California. And he has been butchering, just taking the axe to these gun laws. And the shitty part about it for him is he ends up going, this all ends up going to the Ninth Circuit, which says lol and no, and then denies everything. Now, St. Benitez has done some great things in the Second Amendment fight. If you're from California, you'll know about the Magazine Freedom Week, where basically there was kind of like a week lapse in the law where it wasn't stayed and the stay hadn't been applied for. So there was like an entire week period where people from California were basically buying out every magazine they could find on the internet and having it shipped to their house. So there are options. There are times where things have worked out, but it's still not getting better. California is still behind a wall of tyranny. They still have the handgun roster. They still have a lot of problems. And yes, it should go away. It's unconstitutional. It's a massive infringement. And Judge Benitez agreed and said it's a massive fucking infringement. That said, in California, the Ninth Circuit did agree to stay the injunction on this back in February, and we are now getting to the oral arguments that are being scheduled. So we are going to listen to those, and this is out of the Ninth Circuit. It's a shorter oral argument, guys. It's not like the Supreme Court, but it is the Ninth Circuit, and we're going to do this. And now you look at this, you're going to say, what's in Pasadena, California? Circuit courts don't have to be in their one location. So like the Ninth Circuit, it's big courthouses in San Francisco, like the Sixth Circuit's down in Cincinnati. But they do have other places where they will hold court and they will have things arranged. And Not Sure said Freedom Week was almost 6 years ago. Wow, time flies. But yeah, I remember that. I was very happy for California to get away with what they got. Everybody got away with down there. So, Zaxarian says California's been garbage since Reagan gave illegals amnesty and Save Our State initiative was overturned. Well, California, I mean, to be fair, guys, the gun laws in California and California's had problems all the way back to the, I think it was the Miller Act. Or no, what do they call that act? Basically, in 1968, a bunch of Black Panthers showed up and did an open carry protest with shotguns and M1 carbines on the steps of the Milford Act. The Milford Act. And California, that's how California banned open carrying of loaded long guns, was at that point, because a bunch of scary Black people showed up and riled them all up. So California's had a long problem with this. It's not just a recent thing. Yeah, Reagan passed Milford. Yes, he did, when he was governor of California. So anyway, we're going to get to this. Let's get to it, chat. It's not super long, but it is very interesting. I've listened to it a little bit already, but we're going to get going on here. There is no closed captioning. I'm sorry. So if you guys are hard of hearing, you're going to have to suffer, and you shall survive. But this is the United States Court of Appeals for the Ninth Circuit. This is their actual YouTube page. So, hold on one second, chat. All right, chat, here we go.
Good morning, and may it please the court. Micah Moore for the Attorney General. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
Please.
So, guys, remember, the Attorney General is the Attorney General for the state of California. Obviously, they want these laws to survive. And here we go. These are the bad guys.
The clock.
The challenge laws require California residents to pass a background check before they can acquire ammunition, just like they must to acquire firearms. Those background checks allow the state to confirm that those who receive ammunition can lawfully possess it. Plaintiffs in this case don't challenge the premise that governments can disqualify certain individuals from possessing ammunition. Their core theory is instead that the background check requirement violates the Second Amendment on its face. That theory fails.
Counsel, I want to interrupt you here. I just want some clarification. Is it clear that this is a facial challenge?
Yes, I think plaintiffs can speak for themselves, but they've confirmed in their answering brief that this is a facial challenge to the background check requirements.
I saw that in the prayer for relief that they did, they said that it was a facial challenge and alternatively an as-applied challenge, but I didn't see anything in any of the pleadings that suggested that there was anything particular to these plaintiffs.
I think that's correct, Judge Bybee. There's nothing in the complaint that suggests that this challenge is limited to the facts. And of course,
the district court acknowledged that this was a facial challenge?
Yes, well, the district court enjoined the statutes in their entirety, and I don't think there's anything in the district court's order that suggests that the injunction only runs as to particular plaintiffs.
Now, chat, why they're talking about the facial challenge. The facial challenge is that the law on its face, as presented without even the idea of enforcement, is automatically unconstitutional. It's facially unconstitutional. And yes, Judge, the lower court struck it completely and enjoined it completely. It is a facial challenge that it is completely unconstitutional in all aspects. So that's what they're arguing here. Remember, there's facial and as-applied challenges.
Plaintiffs or facts.
But why are we considering all of the statistics if this is an on its face challenge?
I think because if it's a facial challenge, the plaintiff's burden would be to show that the statute is unconstitutional. There's no set of circumstances under which the ammunition.
But in that case, why do we even bother with looking at, for example, the wait times or the denial rates or the rejection rates?
I think because the Supreme Court has suggested in Bruin that if you have a background check requirement that's being applied in an abusive manner, and I think if there were features of the scheme that run from the statutes that are causing it to be applied in that way, then that would be
But wouldn't that be an as applied if California said you have to pass the test, and the test was taking 60 days, then we might say it's abusive. And if the regulation said 60 days, that might not be on its face. That might be an as applied challenge, wouldn't it? Or if there turn out to be unusual wait times in application, that feels like that would be an as applied challenge.
I certainly agree that there's aspects of plaintiff's challenge that sound as if they be more properly brought as an as applied challenge, but I understand, and they can correct me if I'm wrong, their argument to be is that there's an inherent risk anytime anyone submits to a background check that they're going to experience one of these issues or run into long wait times, and the fees themselves are prescribed by regulation.
In an on its face challenge, are we looking to see whether any person in California might be subject to an abusive time or an excessive wait time? Or are we looking for something else?
I think in a facial challenge, they would have to show that there's no set of circumstances in which the statute can be applied in a constitutional way. I do think that the record suggests that their facial challenge fails, because what the record shows is that in the overwhelming majority of instances, people are able to get the background check completed in less than a minute. And so I don't think that's I think this discussion is revealing that their facial challenge might fail on the merits, but that wouldn't speak to any future as applied claim that someone might bring if they do run into a different situation.
Thank you.
Oh, it's only a minute infringement. Oh, it's only a minute infringement. That makes it okay. No, it doesn't.
And so, I think this is a challenge that Bruin has provided some recent and compelling guidance on. Bruin suggested that shall issue licensing requirements don't violate the Second Amendment unless if they are applied in an abusive manner. The Supreme Court just gave two examples. One example could be if the background check requirements require exorbitant fees. The other could be if they require lengthy wait times that are so long that they amount to a denial of Second Amendment rights. The record does not.
What difference does it make that in order to get to have an operational gun, basically, because you need ammunition to be operational, you have to do it every time you want ammunition, as opposed to maybe a year you have to renew it or the like?
I think that's certainly something that the court can take into account in evaluating whether the background check requirements are abusive. But I don't think that fact alone can change the result here, where the record reflects that even if you are submitting to the background check multiple times to purchase ammunition, in each instance you do so, it's most likely going to take less than a minute to complete. And so I just don't think that fact alone can change what the record shows. Something else that I also think is meaningful is that
when you say less than a minute, are you referring, because apparently there's various different types of background checks. And some of them says it takes 5 to 6 days, and et cetera. Which one are you actually referring to?
So I'm referring to all background checks, but the majority of background checks that people request are standard checks, which are subject to an expedited process.
So there you have to be in the federal automated firearms system.
Yes.
And how long does that take, or what is that process?
So most firearms are in the automated firearms system because the state has required registration for handguns since the 1990s and for long guns for the last decade. There may be issues that can arise if your AFS registration is not up to date. And so that's something that could happen if you change addresses. But for those individuals, the department provides a self-service website where firearm owners can initiate the process of updating their records.
What if you don't own a firearm? What if there's no record of you owning a firearm? So either you've acquired it in some other way, or you have access to someone else's firearm who is in the system, but you're not already in the system. Then what happens?
So if you own a firearm that's not in AFS, you can submit a firearm ownership report to the department.
What if you just go in and you just say, look, I want to buy ammunition, and you're not already in the system because you have not indicated to California that you've purchased a firearm?
Okay, so if you don't have a record, then you have the option of requesting and passing a basic check, which doesn't require enrollment in the automated firearm system.
So
But
if you haven't already indicated to California that you own a firearm, you have to go through the basic check?
Well, you may not have had to, you don't have to indicate to California to end up in AFS. It also pulls from firearms vendors' records. And so it's more, have you purchased a firearm in the last years in California, then you should be in the system.
Okay, but if California can't verify that you own a firearm, can you still buy ammunition?
You can still buy ammunition, yes. You just have to request and pass the basic check.
And okay.
So has any court held that footnote 9 of Bruin applies to the purchases of ammunition?
I don't think we have a case applying footnote 9 in the context of ammunition. There are certainly decisions that have thought about footnote 9 in the context of firearms background checks. And so I think
there's a serious distinction between a firearm and ammunition, and that a firearm is somewhat durable. You would assume you'd own it for quite some time. Ammunition is expendable. You'd be purchasing ammunition repeatedly. So in footnote 9 is talking about a licensing process as opposed to permitting. So it seems that you're asking us to, without authority, stretch what footnote 9 means to say that we have to find that this was an abusive scheme before it was unconstitutional.
I definitely take the point that Bruin was decided in the context of firearms, but I do think the guidance that it offered is also relevant to ammunition. What the court suggested is that the focus should be on whether or not the requirements are abusive and that whether or not they're requiring undue wait times or exorbitant fees. And I think that's analysis that can be applied to ammunition as well. And the fact, I definitely take the point that ammunition is different than firearms, but I do think these background checks are different than firearms background checks in a way that supports our position as to whether or not they're abusive.
So,
they require...
I'm sorry.
Sure. I was just going to say they require shorter wait times. They cost less than a firearms background check. There's no waiting period that applies to ammunition transactions in the same way as firearms transactions. And so in most instances, you can leave the store with ammunition rather than having to wait 10 days as under the firearms regime.
So I understood your brief to argue that the purpose of this is to prevent prohibited possessors from having operable firearms. But isn't that accomplished by the background checks and the schemes to control the purchase of the firearm? So now a prohibited possessor is going to come in and just buy ammunition. It seems like it's a bit of a stretch that this is going to somehow increase your effectiveness in policing prohibited possessors.
Well, I think the reality is that the firearms background check doesn't serve a purpose where someone's able to obtain a firearm through other means. And so the Jones Declaration, for example, that we cited speaks to this. That declaration described law enforcement investigations that started off from a denied ammunition purchase. And in several instances, the law enforcement was able to recover firearms that had been obtained illegally. And so I think that's the additional enforcement benefit that the ammunition background checks are providing, even if there's a separate firearms background check requirement.
Would you? I'd like you to turn to what test we are going to be applying. Are you familiar with our decision this year in B&L?
Yes.
Okay. So how does this fit into B&L's analysis as to whether a restriction on commercial sale of ammunition is within the plain text of the Second Amendment? So do we even get to the historical analysis?
I think this is a case where the court could not get to the historical analysis. B&L suggests that the relevant test is whether or not the regulation meaningfully constrains the right to keep and bear arms. Even separate from B&L, that test was established in Teixeira. And so I think applying that analysis here, plaintiffs just haven't shown on a facial basis that these background check requirements are preventing individuals from being able to keep and bear operable firearms for self-defense.
How is it operable if you can't get the ammunition?
Well, I think our argument is that you can get ammunition. It's just that you have to pass the background.
Now, this lady's going to probably be highly Democrat, but that's always, I love the argument. Well, who gives a shit if it's operable? It's like, yeah, you own a car, but you can't buy gas. It's worthless. Now, some of you guys are asking, why are they asking the question they're asking? They might steel man arguments. And remember, it's just like the Supreme Court. They're not necessarily asking questions they need to know the answers to. They might be asking questions to give answers to the other judges. They might be asking questions to give to the other side, the other attorneys. Just keep in mind, there's a strategy behind all of this. They're not just it's the Ninth Circuit, so they are kind of siding with her probably anyway. I mean, keep that in mind as well. But generally speaking, there is an idea of these questions are shaping the discussion.
Background check requirement in order to do so.
But the point is that it's an infringement on that right. So you can't operate a firearm without ammunition. And I think Jackson is our case that says that it's part and parcel of the Second Amendment right to keep and bear arms. It's meaningless unless you can have ammunition to go with it. And BNL and Tejada were addressing the acquisition of firearms. I think BNL was really more, it was purchasing firearms at trade shows or something along those lines, and you could acquire a firearm like 600 feet away. So it really was no meaningful infringement on your right to acquire a firearm, which seems very different from a scheme that requires you to get permission to purchase ammunition every 18 hours. I mean, these expire so quickly. That strikes me as very burdensome.
Well, I guess a couple of different points. I think first, starting with Jackson, this court has recognized that ammunition is entitled to Second Amendment protection, and we aren't contesting that at all. But what the court has said is that ammunition is protected under an ancillary protection, and that protection is not itself absolute. It's only to the extent that it's necessary to realize the right to possess a firearm for self-defense.
So do you think this nuance of describing a right as ancillary survives Bruin?
I think it does. I think this court is bound by BNL, and in BNL, the court held that Teixeira's text and history analysis is consistent with Bruin. And so I do think this court's prior precedent on ancillary rights and when they implicate the textual right of the Second Amendment does apply here.
It's pretty hard to say that ammunition doesn't, because a gun without ammunition is not usable. So,
see, guys, they're eventually getting to the pushback part here. They're giving her a lot of ground, but then they're like, but it doesn't fucking make any sense. And you guys see how quickly even these guys are pushing back.
it's not ancillary, it's intrinsic to having a firearm.
I think that's not quite what this court has said. But I also don't think it's a principle that we deny that you need to possess ammunition in order to have an operable firearm. Our position is just that plaintiffs haven't shown that the background check requirement is meaningfully constraining their right to possess firearms for self-defense. So if there are no further questions, I'll reserve the balance of my time for rebuttal.
All right, thank you.
That's not good the way that kind of ended, where they're just like staring at her like, that was oof, 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 oof.
Good morning, Your Honors. May it please the court, Matthew Rowan on behalf of the plaintiffs. The district court described California's ammunition background check and anti-importation regime as an extensive and ungainly, first of its kind, sweeping statewide restriction on a phenomenal right that is unprecedented in American history. That description is not only correct, it undersells things. Not once in the first 240 years of this country's history did any state see fit to require law-abiding individuals to submit to a state investigation each and every time they seek merely to acquire the ammunition without which their firearms are inoperable. That's not because ammunition sales or background checks are some newfangled innovation. Ammunition sales predate the founding, and there is a tradition in this country of limited, minimally burdensome firearm background checks that dates at least back 100 years. Yet it took long after that for any state to even think of implementing such a regime, and California was the first to actually do so 5 years ago. Given that historical reality, the idea that any ammunition background check regime could pass muster under Bruin and Rahimi strains credulity. But this court doesn't even need to decide that question to affirm the district court's decision, because California's one-of-a-kind regime is in a league of its own. And so I want to start just by going through the Second Amendment analysis and explaining why.
Before you do that, would you address the question of on its face versus applied? Is this
Sure.
an on its face challenge?
So this is a facial challenge,
All right.
and I would, I think the right way to think about facial challenges are nicely described in this court's en banc opinion in Lopez Valenzuela, where you were in the majority in that case from 2014. And what Lopez Valenzuela says is you look at the relevant constitutional decision rule. That's the phrase that was used there. There, somewhat confusingly, the relevant constitutional decision rule was Salerno's due process standard, separate from Salerno's facial challenge dictum. And what the court said there was, yeah, even though one of the actual plaintiffs in that case could have been constitutionally detained, that was Arizona's Prop 100 laws that basically deprived any person who wasn't here lawfully present from the ability to get bail. They said even though one of the actual plaintiffs could be constitutionally held without bail under a different statute, that didn't render the statute not facially unconstitutional, because what you do is you don't look at sort of individual circumstances. You look at the relevant constitutional decision rule.
So what is your burden in this case?
Sure. So we think that we have a threshold burden under Bruin, and we think that the threshold burden is very easy for us to satisfy here, given that this is a complete gatekeeping on the ability to acquire ammunition.
And so your position, you're going to take the strong position, which is that there can be no background checks for ammunition. Is that your position?
We do take that position. And we think, one, I mean, clearly it implicates the Second Amendment to have a regime.
Before you get to that, because I want you to address B&L here in just a minute.
Sure.
in terms of framework. So the question of sort of the wait times here is largely irrelevant. Your position is that any delay, even de minimis delay of, let's say, 60 seconds, even if we had 100% of background checks being completed in less than 60 seconds, that would still violate the Second Amendment.
So that is our position with respect to ammunition background checks. Mm-hmm. And I'm happy to sort of talk about that. But the reason why, even if you don't agree with us on that, the reason why the facts matter is the relevant constitutional decision rule here is Bruin and Rahimi's how and why test. And how, you have to look at not only what the statute says, but how it actually operates. And part of how this statute, or many statutes, operate is dependent on the fact that rather than set up a database that actually works, which is how Prop 63 initially was going to do, the sort of initial version that the voters of California approved, required California to set up a centralized searchable database where your number would be your same as your driver's license number, and vendors would have access to it. And just like the Brady Act, they didn't just, Congress didn't just say NICS starts overnight. They gave the FBI 5 years and a bunch of money to set up a system that works. Whereas here, that's what the voters voted for, but the California legislature pre-amended Prop 63, and they got rid of what would have been Section 30370C. And instead they said, no, we're going to piggyback on the AFS system. But the problem with the AFS system is that it relies on dealer inputs, and it was never intended until this regime was put in place to be used as a gatekeeper to the exercise of anything else. So, I mean, we have evidence in the record where, the drop-down menu, when you go to buy a firearm and dealer puts it into AFS, you have things that say Huntington Beach, BEACH.
Yeah. Okay, I have to say, I'm confused by all of this. I mean, everything that you're saying, I understand makes a lot of sense, but it feels like it would make a lot more sense if you had an as-applied challenge. So I understand on the facial challenge, I think I got the right answer to the question, which is that that even if California successfully integrated this from the beginning, if they had studied it for 5 years, worked all of this out, and had 100% at 60 seconds or less, that would still violate the Second Amendment. Isn't that your strong position?
That is our initial position.
Okay.
And if you don't agree with us on that, still under the facial challenge rubric, the how facts actually matter, because the relevant constitutional decision rule under Bruin and Rahimi looks at the how and the why. You have to compare historical analogs in terms of the burden that they impose on the exercise of the fundamental Second Amendment right to the burdens that the regime imposes. And the way we know, I mean, this is an unusual case, not only in that we have a record, but we have 2 different time periods of records, because the case was back, before the district court in 2019 and then again in 2023. And what we've seen is that thousands of Californians have been unable to acquire ammunition as a direct result of this regime. So I wanted to talk about B&L for a second. So we don't think that the B&L framework is.
Do you have any plaintiffs who have standing
Yes.
to challenge those delays? I didn't see anything in your complaint that suggested there was any individual person who had suffered a delay.
So we have a robust record here. I would commend.
Yeah, is there anything in your complaint that suggests that you've got a plaintiff?
So the
who suffered a
complaint was
delay?
filed before the regime had
Which
gone into
indicates that it's an on its face challenge.
right? But now it's gone into effect, and we have declarations in the record that the district court relied on. So Plaintiff Johnson at ER 58, after he moved, he was unable to use the standard check. It took 110 days for California Department of Justice just to respond to him. We know that Kim Rhode, the lead plaintiff, has had to spend thousands of dollars storing ammunition. She's an Olympian, and she can't get it to her house. This court's precedent, including cases like Montana Shooting Sports Association, makes clear that expending time and money to comply.
And guys, if you don't know, Kim Rhode is a trap and skeet shooter. She is an Olympic champion. She's one of the few Olympians that have won medals in like every Olympics she's been in, and she's been in Olympics forever now at this point. She is a phenomenal shooter, and that is who this is about. I forgot to mention that earlier. So, yeah, and think about how much to be a world champion, gold medal trap shooter. How many rounds do you think she fires? A fucking gajillion. She can't order ammo online. She can't have she's got to go to a store and have it background checked every time. She can't just have it shipped to her house. It's very burdensome for her.
With a burden on the Second Amendment is sufficient for standing. We also have an associational plaintiff, CRPA, and we have two declarations from the treasurer and the president, respectively.
Once we go to let's take Mr. Johnson because
we said that earlier. The facial challenge is the law itself is 100% unconstitutional. The way it's written is unconstitutional. As applied means as you're applying it to this person or this class is unconstitutional. With that said, though, even the Supreme Court has argued these kind of blur together in a lot of spots. But yes, facially applied means the way the law is written is bullshit. And I'll say it again, but that's what that means. It means the law is bullshit as it is written. So they're saying California's law is bullshit regardless of who it applies to.
110 days is a disturbing figure. Once we go to that, doesn't that make this an as-applied challenge?
So it doesn't, Your Honor, and I really think that facial and as-applied challenges, it's confusing.
Well, it's facially unconstitutional because it's an infringement on the Second Amendment. That's how it's facially unconstitutional. You're not allowed to do this. The state's not allowed to do this. That's what makes it facially unconstitutional. It's an infringement on your right to keep and bear arms. When it becomes a licensure issue, it's on the state to explain why the licensure is valid and the licensing and the background checks are valid. So that's why it's facially. It's just like if they had a law saying the cops are allowed to search your car without a warrant. It's facially unconstitutional because it violates the Fourth Amendment. You need a warrant. The cops just can't show up. They need probable cause. So just like with the Second Amendment, the right to keep and bear arms, you guys are overthinking this. You're overthinking this. They're saying it violates the Second Amendment. How? Because it violates the text of the Second Amendment. It's not. You guys, like I said, I think you're overthinking this. It's literally saying this is the parameter. The right to keep and bear arms shall not be infringed. You're infringing on the right to keep and bear arms. So that's why it's facially. And I'm not trying to make fun of you guys. I'm just saying that's what a facial application is, a facial challenge. It's literally because it's violating a constitutional principle.
But I do think I would take a look back at the majority opinion in Lopez Valenzuela that explains that the facts often actually matter in as-applied challenges.
So wait, I'm sort of confused about the steps and Bruin. So it's your burden to show.
And I know you guys aren't lawyers. That's why I'm just saying, when it's literally, I don't think Sean understood the double entendre. I didn't get it. I missed me. So. Keep at this thing in California. You can get ammo sent to your house. You just have to have the curio and relic. Okay. And have a letter of permission from the state. It's how some of us get around that rule. Really? Okay. I thought by now all you guys were screwed. Facial means you call Barnes. No. I understand you guys. Okay. If you guys are making the facially applied jokes, And AD says New York has an ammo background check too. Yeah. And if that gets challenged, the Second Circuit will probably support it anyway. But you would make the same arguments, especially now with Bruin and Rahimi. You could say it literally violates the text of the Second Amendment. Therefore, it's facially unconstitutional. That's all you have to do. That's the only argument you have to make. So let's see here. What's Cedar Rose saying? You thought it's a challenge the internet comes up with then. AD saying it doesn't violate the black letter text of the Second Amendment. It is, though. It's an infringement. Licensure is a restriction. Background checks, you're restricting people. It's an infringement. It doesn't say you're allowed to do that. So it is 100% an infringement. Andy says the toy doesn't mention ammunition. You're right. But the idea is that you can't own the weapon and the accoutrements necessary for it. Well, if you own a bow, but you can't own the arrows, is the bow worth anything? No. You know, that's the entire point of it. Like, you could own a trebuchet, but you can't own the rocks. You know, you could own the saddle, but you can't own the horse. You know, you need the ammunition as part of the arms. Arms includes the accoutrements and supplies necessary to functionally use a weapon. So it just sounds pornographic. Well, but yes, guys, and like I said, there's a lot of Supreme Court case law. This, like I said, the as applied and the facial challenge, they kind of blend together in a lot of spots. And there's times where they're apparent, like they're separate, but then they still blend. So, like I said, don't get worried about that. It's literally just saying this is bullshit. It's not legal. AD says that's not how the states see it. I understand. And it's just like being a black guy in 1960. A lot of states disagreed with Brown versus Board of Education. It just takes a long time for them to be buck broken. So, I mean, that doesn't mean it's not illegal. I'm not humorous, but no, I actually am. I am. We did it, and I don't want to keep having to break 5 minutes to do the facial versus as applied. We already kind of said that once at the beginning. I kind of want to get through it, then we can do it again. So I'm totally fine. It's just, you know, we mentioned it once. We can't keep stopping to get to that point again. So that's all I'm trying to say. What?
So that this is an arm that's the Second Amendment protects, right? And it's the government's burden to show that there's a historical analog. Aren't I correct there? So where does the individual challenges come in?
So you're correct. And that's definitely the analysis that Bruin sets forth. And we think that it's a very clean analysis here, and that, of course, a law that says you have to pass through a gate that the government controls in order to acquire ammunition, of course that law implicates the Second Amendment. So we think that, you know, B&O Productions and Teixeira, cases like that, where you can't purchase firearms at 2 fairgrounds, but you can purchase it everywhere else. The difference between that law and a law like this is this applies always and forever to everyone. And it is an absolute gate that you have to go through that the state controls. So, of course, that implicates the Second Amendment. And I think Bruin footnote 9, like the only way to make sense of Bruin footnote 9 is to understand that background check regimes and licensing regimes, which this of course isn't, implicate the Second Amendment. Otherwise, how could something ever violate the Second Amendment? The only logical way under Bruin and Rahimi's sort of 2-step framework for something to violate the Second Amendment is if you've passed the threshold inquiry. So we think that the sort of B&L production substantial burden sort of standard is not the correct way to approach a law like this. But even if you disagreed, or if you thought the better course of valor was to assume without deciding that you were in sort of the B&L Productions framework, of course, this statute imposes a substantial impairment on people's ability to acquire
The
operational
government argues that that bullets are ancillary. That seems to go to the first step, whether this implicates the right of the people to keep and bear arms. So what's your position on that?
So, I mean, this court has said that they are ancillary. I think that the way that I would understand that with respect to ammunition is that they're ancillary in terms of being inherent. I mean, ammunition is itself an arm. So I don't think that, the ancillary piece goes to ammunition. What this court has said is it goes to the acquisition. But of course, one cannot possess what one can't get. So I think it's a mistake to think of acquisition as ancillary just because the Second Amendment doesn't say explicitly purchase or acquire alongside keep and bear. I recognize that Manny and B&L Productions take a somewhat broader view. And so if the court wants to sort of say, look, we're going to assume without deciding that we got to follow this substantial impairment test to get through the threshold, we think that's not the right way to sort of do this a priori under Bruin and Rahimi. But we think clearly it's passed here because, again, we have a record.
So do background checks for firearms, does that come within the Second Amendment?
Of course.
That comes within the plain text?
Of course. I mean, I think
Okay,
otherwise.
Okay, that I understand that B&L doesn't cover that, but we do have 3 other circuits that this year have said that background checks do not come within the plain text of the Second Circuit. So you're urging us to go into conflict with, by my count, the 4th, 5th, and 10th circuits.
So what those courts have held is twofold. What they've held is, one, that if you frame the question as the conduct plus the restriction, so if you frame the question as, do you have a right to acquire a firearm without passing through a background check? Well, that's not covered by the plain text. But they've also then said, but of course, we can't say that background check and licensing regimes do not implicate the Second Amendment because that would overrule Bruin, which of course was a licensing regime case. And again, I think Bruin footnote 9 would make no sense if you thought that background checks didn't implicate the Second Amendment. And I mean, again, perhaps the safest way to do this is to just say, fine, we'll assume that B&L Productions is the correct standard for here, pass through the threshold, because of course, a law that prevents thousands of law-abiding citizens from acquiring ammunition, without which a firearm is inoperable, of course that imposes a substantial impairment on law-abiding citizens' ability to acquire arms. So
even if it's a 60-second check.
So I think even if it were a 60-second check with respect to ammunition, because as Judge Beatty pointed out, ammunition is expendable. In the record, when California first passed Senate Bill 1235, which pre-amended Prop 63, they did an economic assessment, and one of the assumptions was that people will buy 40 rounds at a time. 40 rounds doesn't last very long if you're training, which is something that you want people to be able to do. So people are going to go buy ammunition all the time.
Does California limit how much you can buy at one time?
So California doesn't, but we know from the record that people aren't just sort of spending money willy-nilly. I think
although Ms. Rhode might buy it in bulk.
So Ms. Rhode might, although Ms. Rhode may not have to pay for it herself because USA Shooting does provide her some of it. So yes, I mean, there are certainly special cases, but what we know from the record is that people aren't willing to spend the 5 times as much as a standard box of 22 round ammunition just to pay for the $19 basic check, which soon will be more expensive, as my friend on the other side pointed out in the footnote in their reply brief. So I do want to sort of shift to the historical tradition part of the analysis.
Can I ask you a question before you go there?
Of course.
So it seems like the real battle in these cases is how we define the proposed conduct. If you define it as Bruin did, as the right to keep and bear arms, it falls clearly within the plain text as opposed to saying the right to have a license to concealed carry or to carry in public, whatever. So B&L described the conduct as contracting for the sale of firearms and ammunition on state property, which is not in the text of the Second Amendment, but it could have been defined differently. And are there any principles? It seems like the case law is a little bit all over the board. So any principles that we can apply to decide how to define the conduct at issue?
So, I mean, I think that sort of when you're looking at smuggling in the restriction into deciding what the proposed conduct is, you jumped the tracks a little bit. So, I mean, I think sort of a priori, I'd say the way that B&L or Manny sort of framed things is just wrong. I understand that this 3-judge panel is bound by those decisions. So what I would say is two ways of distinguishing them, and one of just saying that even if those apply, we pass the standard here. So the 2 ways of distinguishing them is in cases like B&L and Teixeira, again, they're narrowly geographically limited. And you can go elsewhere and you are free to acquire arms 600 feet away. Whereas this is always and forever, everyone is at constant risk and everyone has to go through this. Judge Bybee, one point on the facial challenge is one of the problems with doing an as-applied challenge here is the sort of difficulties with actually getting the state to run the background check, which they decline to do upwards of 10% of the time, is that you don't know why they're not running it. So it would be very difficult for you to actually bring an individual as-applied challenge because, of course, they would moot your challenge. So, I mean, I think when you have
then it's capable of repetition yet evading review. But I mean, it seems to me if you came here with Mr. Johnson and said, Mr. Johnson's licensed gun owner has no impediments to ownership to acquisition of firearms or ammunition, and in the process moved, and it took California 110 days to get the problem solved. That seems to me to be a pretty substantial burden.
Well, we certainly have done that. I mean, he is a plaintiff in this case.
Right, but that's an as-applied challenge. So, and that's just why I'm so confused. I was confused by the briefs. I was confused by the district court's opinion because I didn't see the district court ever acknowledge that this was a facial challenge or ever cite any standards for what that meant.
So again, I would just go back and look at the Lopez Valenzuela opinion, which I think explains sort of how this works. And I do think, I mean, just quickly on the B&L point, I mean, I think the way to think about this as different from those cases is that the state is controlling your access to something that is necessary to exercise the Second Amendment right at all. And it controls it always. You can't go out of state and bring it in because of the anti-importation regime. You have to go through this process, and for a large and arbitrary percentage of the people, they won't even do it. So if that doesn't implicate the Second Amendment, then it's hard for me to understand what would. Again, I think Bruin footnote 9 only makes sense if licensing regimes clearly are covered by the plain text. But I mean, I recognize that B&L Productions seems to state a very broad principle. And so, if the court wants to just say we're going to assume that substantial impairment is the right standard, then of course substantial impairment matters. I mean, I also think there's no way to do, Judge Bybee, a substantial impairment analysis on an individual basis, because otherwise you'd have a bunch of people challenging the statute all the time, which is why you sort of have to do this on a broad basis. And again, the how and the why are the standards at the historical tradition stage. And if we look at the state's proposed analogs, I mean, they're not remotely in the ballpark.
Well, you could easily come up with a statute that would fail the substantial, the meaningful restraint, our language from Teixeira and B&L,
right,
on its face. If California said you're going to have to wait 60 days, and it was right in the statute. Okay, doesn't matter how 60 days. It's a waiting period. That's on its face. You win that one easily.
So I think part of the problem with what California did is they didn't do step 0. They didn't create the database that is necessary for this to work for.
And this is part of the problem, chat. California passed the law. It said we have to do all this stuff, and then an even bigger problem happened. They weren't ready to actually do it. They're still not ready to do it. It's still a disaster.
Everyone.
And so if they did it by driver's license, that would satisfy the Second Amendment?
So we don't think
I thought your position was that any restraint would.
So that's certainly our strong form position. But as Judge Benitez himself pointed out, if they'd gone with Prop 63, we'd have a much tougher case. We would have to win, assuming that it actually worked, but we'd have to win sort of the strong form argument, because the way that worked is that it was going to be a 4-year license where you paid $50 once
and he's bringing up, and this is actually the judge kind of thought he had him, but he's just trying to say, look, the previous version of the law would have been actually something that would have been harder for us, even under Bruin and Rahimi, to challenge, because it was as I said at the beginning, chat, it was a 4-year license. You can buy all the ammunition you want. But California decided to ratchet up the retard and make it tougher and tougher and tougher and tougher, which makes it for them easier and easier and easier. The more restrictive you get, correspondingly, The more restrictive you get, the greater the constitutional threat. So if they had done like a moderate thing, there would have been a moderate threat. But they keep pushing it, and then the risk keeps pushing along with it.
Just used your, because the way that worked is that was going to be a 4-year license where you paid $50 once and it just used your driver's license number and it would be instant. But instead of spending the time and money necessary to put in the database, that again is the gatekeeper to one's ability to acquire arms, period. They said, no, we're going to piggyback on this other thing that has never been used for this. And we know now that it doesn't work. And so just quickly on historical tradition. So, I mean, the state's analogs, they try to rely on loyalty oaths, which you entirely control and they're one and done. The idea that that's sort of similarly burdensome to a regime where you have to pass through the state's gate and you can't force them to do it, and you have to do it each and every time you want to acquire ammunition.
Counsel, your time is going to expire, and I'm going to ask the chief to give me permission to, the presiding judge to ask permission to a different line. All of this is avoided if there's a problem under the domestic. Under the Dormant Commerce Clause. So would you just take a minute and explain to me your best argument under the Dormant Commerce Clause?
Sure. So the state concedes that vendors need a physical presence and a license in California to sell ammunition to Californians. The only option for an out-of-state vendor to sell to a California resident is to funnel sales through a select few licensed in-state vendors. That's textbook facial discrimination, because what California has done is they've hoarded a local market for a favored group of local merchants. We also have real evidence of discriminatory effects.
What California has done is said you have to have a face-to-face transaction here.
Actually worse than that. So if you look at a case like Black Star, which I think is their best case, which was the Arizona exception to the 3-tier system. So that had a face-to-face requirement. And what it said was you can sell, if you're out of state, you can sell 2 cases of wine in a face-to-face transaction to an Arizona resident. Here, you cannot do that. You have to ship it to an in-state vendor for processing. And we have evidence in the record that many in-state vendors that are licensed are either refusing to accept the processing or they're basically charging exorbitant fees.
So if you're a Colorado manufacturer of ammunition, obviously you can't ship it in over the internet. So you can't ship it directly to the house via Amazon, for example. But there's no restrictions on how much you can sell to a licensed vendor in California. I mean, Colorado manufactured ammunition is being sold in California.
Well, so I think the relevant distinction is not between.
Am I right? Let me just make sure I'm right on that.
Certainly
point.
Right.
Okay.
The relevant distinction is not between Colorado manufacturers and California dealers. It's between California dealers and everyone else. And what California has done is they'd say, in order to have access to this market, you have to go through the select few licensed dealers. The only other regime in history that looks anything like this is the 3-tier system in the alcohol context.
How would this work, for example, on the sale of cigarettes or alcohol if you can't sell to minors? How would you do that outside of a face-to-face transaction? So
alcohol, of course, has its own sort of constitutional allowance. And the way that works is you have to sell basically from out of state, from the states that have the 3-tier system, you have to sell to an in-state wholesaler, and then they sell to retailers. Mm-hmm. So in many states,
but how do you deal with a minor problem?
Yeah, so
the 3-tier system deals with a much broader problem.
Right.
But
So
how do we deal with the minor problem and cigarettes?
So you can make it criminal to possess cigarettes if you're under 18. So that's step one. And if you want to have a face-to-face requirement, you could require licensure. I mean,
but doesn't that sort of limit it to in-state sales?
So no, because I mean, again, this is not just the face-to-face requirement. There's also section 30314, which is the anti-importation regime, where you cannot bring it in with you, period, unless you have it sent to an in-state vendor. No state in the country does that for any product other than alcohol. Not for cigarettes, not for anything else. And the way that they do it is they say, it's a crime to sell to kids. So if the kid doesn't if the kid age verifies, well, that's a crime. And so they have criminal laws for both the seller and often the shippers and the children. And that's the regime that works for tobacco. And there is no other regime in the country's history, not now, not ever, that says you cannot bring a product in unless you funnel it through a favored select cabal of favored in-state vendors, which can then charge whatever price they want. I mean, the state points out, I know I'm far over time, but the state points out very briefly that, oh, it's only $1 fee for the in-state processing. That's only if you are there the moment the product arrives, which almost nobody is because it doesn't come with them. It has to come through a shipper. So unless you are there the second it arrives, they can charge whatever fee they want. And we have evidence in the record, the Abel's declaration and the ammunition depot declarations at ER 64 and 67, that they're charging exorbitant fees, which has had the effect of just completely decimating out-of-state vendors' sales to California residents. That's textbook discriminatory effects.
Okay, thank you. Thank you for your additional comments, and you have some time left for rebuttal.
So I wanted to just start with the Dormant Commerce Clause claim. I think what the court's precedents show that requirements have been invalidated as discriminatory on their face when they impose requirements that are so associated with protectionism that they're virtually invalid per se. I don't think that that's what these statutes do. Anyone, regardless of where they're incorporated or where their workers are located or where they manufacture their ammunition, can apply for a license to open up a vendor location in California. If not, they do have the option of having their transactions processed by in-state vendors. My friend on the other side suggested that the fee is just, it's limited. I just wanted to clarify what the requirement is. The fee is limited to $5 if the purchaser is immediately present. The fee that's charged for processing the requirement if the purchaser isn't present has to be agreed on with the purchaser ahead of time.
Is there a storage fee that's not specified?
Yeah, there's a storage fee, but it has to be agreed upon with the purchaser before the ammunition is sent to the vendor. And so the purchaser has the option of declining if it's, but I don't think there's any evidence in the record that suggests that in-state vendors have been imposing exorbitant fees. And then I wanted to quickly return to the Second Amendment claim. Plaintiffs have confirmed that they brought this case as a facial challenge, and Rahimi reiterated that Salerno is the standard that applies. I think what plaintiffs' evidence shows at most is that there have been individual circumstances in which the background check requirements worked less than seamlessly. In many instances, I don't think those declarations show that the firearm owner was unable to obtain ammunition. And so to take one example, my friend on the other side mentioned the Johnson Declaration in ER 5558. That's certainly an instance where someone experienced a regrettable delay in updating their AFS records. But of course, that person also had the option of requesting and passing a basic check while they were waiting for their AFS records to be updated. And stepping back a bit, I don't think there are more than 20 declarations in the record that express some sort of complication with the ammunition background check system for a system that performed 600,000 background checks in the first 6 months of 2023. And so that's not the sort of evidence that suggests that plaintiffs can prevail on a facial challenge. As to the threshold inquiry, I do think BNL is binding because it did purport to establish a standard that applies to ancillary rights. Stepping back a bit, as Judge Bybee noted, there have been several circuits that have been confronting this question about what you do when you're evaluating a regulation that's one step removed from the plain text. And I think the McCrory and the Maryland Shell issue and the Oakland tactical cases show that other circuits are converging on analysis that may differ in its phrasing, but looks quite similar to the analysis in BNL, where you do have to inquire into whether or not there's a practical effect on the right to keep and bear arms. And then as a final point, I just wanted to say quickly on the history, even if this court were to assume that this is a case that gets past Bruin's threshold step, the challenge background check requirements are supported by historical tradition. I think plaintiffs rely quite heavily on the fact that California's system is novel, but Rahimi and Bruin stressed that the Second Amendment was not intended to impose a regulatory straitjacket or foreclose states from adopting new methods for addressing problems, so long as those methods were consistent with historical tradition.
So what's your best historical argument?
I think we have several. I think the loyalty oaths and the founding.
Now, when I read the declaration on the loyalty oaths, it was interesting. It was interesting history. I wasn't aware of all of the history of the various oaths that were issued during Reconstruction. What I had a hard time figuring out was the connection between the loyalty oaths and regulation of firearms. We found one example in paragraph 30 of somebody in Lawrence, South Carolina, that apparently was restricting persons who could own firearms, or if they haven't taken the strong oath. But that seemed like a pretty thin example, and it was the only one that was there.
The Vormberg Declaration speaks only to the Reconstruction era loyalty oaths. We've also cited some pre-founding loyalty oaths in our opening brief, and those are included in the Spitzer Declaration as well.
And did they connect directly to firearms?
Yes, they were enforcing underlying prohibitions on possessing arms and ammunition. And so someone who declined to take the loyalty oaths would have their arms and ammunition confiscated. And in many instances,
the other side says those are one-time, one-and-done type events as compared to this, which is every time you buy ammunition. What's your response to that?
That's correct. It's one time that you have to take the oath. I do think the record also suggests that often the magistrate was required to keep a record in place of everyone who had taken the oath and who had not. And I think that's a very close historical precursor to a kind of database system where you have the option.
A whole range of citizen-oriented rights were allowed, and there was no requirement to revisit it. Isn't that right?
I think that is correct, but what I would stress is that Rahimi made clear that the analysis isn't just to find a dead ringer in the past for something that looks like a modern background check system. The question is whether or not there are principles undergirding that history that suggest that a background check requirement would be constitutional today.
So I think the loyalty oath is your best historical analog?
I don't think we have to show a best, and I think we've cited a number of other examples. 19th century carry licensing requirements come to mind where someone would have to come in and demonstrate that they satisfied a set of eligibility requirements before they would be permitted to carry firearms. And I think that the most important point is what these different historical examples are showing is that throughout history, governments have imposed screening mechanisms to decide whether or not people are disqualified from possessing firearms or ammunition. And I do think that the background check requirements are relevantly similar to that tradition. So if there are no further questions, I'll submit. We ask that you reverse the district court.
Okay, we thank both sides for their argument. The case of Rhode versus Bonta is submitted, and we'll next hear argument in Davis v. Blue Tongue Films.
All right, chat. So that's it. It's a very different thing here, how they went through all of that. Seller saying she's the most libertarian judge in the ninth, and I want her there regardless of the voice. Yeah. Once again, though, I will just say, and somebody brought this up here, J-Rock saying these are all Republican appointees. Republican appointees for the state of California. So you just have to be very careful with little grain of salt there. And PC42 says, I have a massive horse caulk. What's a horse doing with the tube of caulk? So are you a horse that does bathroom refinishing? All right, guys, we're going to get through these. I started a bunch of comments, and we're going to get through these as we go here. Fair Frozen 55 is saying, in Puerto Rico, you must own an arm that uses the cartridge. Registered in the police registry or no sale. You must show your permit, too. No permit, no sale. Wow. That's even so I can't just buy ammo. I have ammo for guns I don't own. I have I have an AUG 40-round magazine, and I don't own a frickin' Steyr AUG. Wish I did. That'd be cool. But that's interesting. That's even crazier. AD is saying, where is the statutory or constitutional authority for an as-applied challenge? Under the idea that the government, you're discriminating against a certain class and then you're constitutionally affecting them. So there are times where that may happen. But as I said, there'll be a lot of instances where they kind of blend together after a while. So it's not like it's an inherent thing. The court has developed how you challenge things. So there's nothing in the Constitution that says, here's how you challenge laws. And there's no statute that says, here are the ways you can challenge a law. So if you're looking for a specific thing, you won't find one. And if that's your question. Nero saying, why is the judge framing the arguments of the plaintiff with the defendant? Because it's how part of this is, like I said, it's testing the arguments, but it's also you're trying to get something established here. Maybe for your other judges, maybe you're trying to get the other side. Here are some problems I see in your arguments. We don't really know. The judges are allowed to deal with it. What's the deal with their voices? Yes, they had Robert Kennedy-itis there. It was a little bad. Charlie says, for $5 Australian doodles, off topic, but I apologize. People are clamoring to see you fist a large jar of mayo. Can you give us a definitive yes or no? Thank you, my liege. I've already done it once. They were just not happy with it, but I did provide them what they asked for. It is on Discord. It was done. And my hand was too beaucoup for the jar. So they got what they wanted. AD says, are they allowed to use strict scrutiny here? Yes. Yes. And, but that said, though, remember, it's not the idea of strict scrutiny, but it's using Bruin with the historical analogs. And you have to go back and find, is that in the tradition of our Second Amendment in firearms regulation in America? So it's not even strict scrutiny. It's a separate thing. But I'd argue it's like a version of strict scrutiny. So yes, they do have a standard they have to apply here. And Travis says, nice, it only applies to law-abiding peoples. Well, going in there and making an argument, no, Your Honor, I want all the cholos and gangbangers to, that's not how you make an argument that wins with judges. Tekevi says, when he brought up the judge's opinion back in 2014, yes, judges remember a lot of the opinions they write, and they can go back and look at that. And yes, you're citing them to definitive things that they can rely on. And it's always a good idea if you can do it. NY Renal Doctor, MD, saying, what remedy does people like us have when states like Cali and New York keep cranking out these laws? You have to keep fighting. I mean, I said this before. This is kind of like the civil rights, Brown versus Board of Education didn't end the civil rights movement. States kept on fucking around into the 70s and 80s, and the Supreme Court and federal courts had to keep smacking them down for decades until we got to the point we are now. So it's going to take a while. Buck breaking a state is not easy, but it will happen eventually. Uncle Bob Spees, thank you for being here, Bob. And once again, chat, remember, Bob, you guys didn't know, Bob gave me a set of nice little nippers in the mail, saying, can they buy powder and primer without a check? I don't believe so. And I think this is meant to be People 1976, but POP is saying there were certainly ordinances about how to store black powder existed. Yes, but it was the idea, from what I understand, storing it within your house if you lived in town. Otherwise, there were restrictions on safety. It wasn't you couldn't have too much or you needed a license. They didn't want people storing flammable material in homes back then because you had fires and houses caught fire all the time. And they say, however, the federal Bill of Rights were not incorporated in the states at the time. Yes. Benitez is now retired. That is correct. He is not. He is on senior status, chat. And if you guys didn't know that, here is Saint Benitez. This is him right here. Roger Benitez. He has senior status in the United States District Court for Southern California. Senior status means that he doesn't take a full caseload, but he still takes cases. So presumably any sort of Second Amendment shit is going to go back to him, and he'll take those cases as they come. But senior status is you're semi-retired. And a lot of judges do that. And you can have semi-retired judges on the Court of Appeals as well. So each circuit court can have senior status judges who have achieved that status. You don't have a senior status for the Supreme Court. You're either in or you're out. And that's probably a good thing because we'd have a million fucking judges at this point. Roscoe's saying, I guess I'll send a super chat to get Sean to promote Bob's GoFundMe another day. Okay, and who's Bob? I don't know who Bob is, so. Yamal is saying, is licensing regime the normal terminology for a state apparatus that facilitates and requires background checks for buying firearms? Yes. You'll hear regime, you'll hear a licensing scheme, and it's not meant to denote that it's bad. Like they call it a licensing scheme or a licensing regime. You have to like the licensing system. It's like the system, the like the licensing institution. It's speaking in that generality of that encompassing term. So it's not meant, they're not calling it a regime like the Assad regime or the Saddam, the Hussein regime, and it's, I understand why you guys, like, you might think that. It's not, it's just a general descriptor of kind of like a complete system there. Yeah, and you're like, but wait, why are they talking about schemes in how this works? And no, it's just the system that's been put in place. And then AD says, this case going to be remanded for the facial challenge? I don't know. I kind of get the feeling they're going to strike it down. I mean, it's the Ninth Circuit. I'd like to think these judges are going to do the legit thing. But remember, even if these judges say, you know what, we agree, this is a bullshit thing, this can't stand, the Ninth Circuit can hear this en banc, and those judges will wipe out this very likely. So I'd like to see this get supported, but it's probably not ultimately going to happen that way. And Lars Larson is saying lots of people in California have been rejected, even though they are able to go buy the gun. They just can't, and then they get rejected for the ammo. And I've heard that as well. In California, it's so ridiculous that you can buy the gun and you'll get approved for the gun. You pick up the gun. Cool. I want to buy some ammunition. Sorry, you can't buy it. You're prohibited. It's that bad. It's that bad. Yes, this is the first time a state has done this, like this bad. It's this bad, this ridiculous. And Fallen Preacher, I hope, he says, why does it keep using regime? It sounds sinister, at least because of the way the media has used the word regime as something to be overthrown. Yeah. And I hope that makes sense. Once again, it's just the licensing system, the system and the process and the ecosystem. We might call it a licensing ecosystem, although that makes it sound really kind of mundane when you say like, oh, it's an ecosystem. It doesn't sound so bad. Calling it a regime makes it sound a little more imposing. Lars is saying in-state vendors refuse to order ammo for you. You have to buy theirs. And that's not a surprise either. Not a surprise either. I've heard that as well. And then Sir Marhouse, been a member for 23 months. Thank you for the report. Says, I'm going home in 3 hours. And that was about 45 minutes ago. So 2 hours and 15 minutes. 0 sleep on a 12-hour flight. But hey, you're going home. So congratulations. You're leaving the land of licenses for a little bit. Congrats. Hope your school went well for you, man. Hope it was going well. Casey in NorCal saying, thank this law to buy a new gun because I didn't have the stupid background check prior to buying ammo for an old rifle. Okay, that is funny. To make it easier to comply with the law, you had to go buy a gun. That is probably one of the perverse incentives. They're like, wait, no, we don't want people buying more guns. But you're like, I guess I'm going to have to. So that's that is an interesting thing when I saw this, that you had to go buy a gun so you could pass your background check. And Sergeant Dormant saying 45.70 is like $40 a box here. Ooh. Oh. That's awful. And AD says, yes, in-state vendors upcharge because of the laws. Of course, they can get away with it. It's just like when background checks for guns, universal background checks happen. Every FFL is going to charge whatever the fuck they want because there's no other way to do it. You have to pay somebody. AD says every ammo in New York is more than $1 a round. I've heard that as well. It's getting out of control. And New York Renal MD is saying the elephant in the room is the ammunition ban has done nothing to stop gun violence. Yes, I know. It's like it doesn't matter. And then AD brings up a question. Why hasn't anybody bought a disparate impact claim for these laws? So here's the issue with disparate impact. That's normally done like in cases of it's racial or it's basically protected class discrimination. And it's only them. Whereas here, this licensing scheme affects everybody. So if this was a case where the gun law was only affecting black people or people regarding their national origin or any of the protected classes federally, that would allow you to do a disparate impact. But until that happens, like if it's affecting everyone, it's not a disparate impact. That's an actual specific term. The disparate impact is, inadvertent discrimination. So this would not be the time for that. Although it's a very good question. Why wouldn't this work here? Well, who is being disparately impacted? What specific protected group is? And in reality, it's everybody's being impacted. And New York Renal MD is saying, my super chat actually has a question. How can they keep doing this? And the slow process of the courts just for a de facto ban on guns. Yeah, I mean, that's, like I said, think about the civil rights movement. Brown versus Board of Education, you won. But then we had, if you guys go through it, it got to the point where states were allowing, enacting and allowing places to discriminate on their own. And the federal government said, no, the Commerce Clause gets involved. I mean, it took a long time. And a lot of court cases, the battle's never easy. The battle against communists never stops. And they'll keep doing it until you stop them. And Matty B says, get this. You can buy ammo with a background check in CA. You can cross the state lines with the ammo, then you're barred from returning with the same ammo. That's, well, I mean, you would say it's stupid, but at least it's consistent with the stupidity of the rest of the law. And Casey in NorCal is talking about the Dormant Commerce Clause. And yes, if you guys heard them talking about it, that is a Dormant Commerce Clause issue, is that it's a discrimination on out-of-state ammunition vendors and ammunition companies. If they want to sell in California, you now have to comply with basically pay to play. You have to come in here, open up a store, pay all California's licensing and rules, which they might not even give to you if you're an out-of-state company. They can discriminate against you. They probably will. Well, now you've got Dormant Commerce Clause issues. We can't let the states start discriminating against businesses and parties in other states like that. You can't do that kind of treatment. So, yes, that is an issue there. And they did address it. They said, look, it's not our strongest one, but we'll talk about it. Obviously, they have other grounds they want the court to rule on, and I think that are probably better for them to rule on and get what they want out of it. But that's how they go there. Jose Rodriguez, how you doing, man? It's good to see you. Saying the horse is helping Nick. You're gonna help him reinstall those cabinet doors, I guess. And then Jose saying, what is the logic of allowing convicted felons to own centerfire and rimfire antique firearms, but making it illegal to own ammo for said rifles? Well, there is no logic to it. I wish there was one, but there isn't. It's all garbage. It's all stupid. Yeah. There's no real. I mean, I wish I had an answer for you, but they don't. It's not, remember, it's not about stopping crime. It's all about controlling. So it's all totally how they do stuff. It's all totally how they do it. I wish I had like I said, I wish I had an answer for you, but I don't. I don't. So. Let me see here. What are oh, Yamal, we'll get to that. Sorry, I'm trying to catch up here. You guys asked a bunch more questions while I was here. Let's see. Let me see here. Let's see. What do you guys? Let's see here. Let's see here. Okay. I think I've caught up now, chat, finally. I think I've caught up. All right, so here we go. All right, sorry, chat. I had to get a bunch of more questions there. Yeah, but Jose, I don't have an answer for you. I wish I did, but I just don't. New York Renal MD says, is there some sort of expedited remedy for bad actors to dispense with these laws? Nope. You got to fight them in court. I'm not joking when I said you need to look towards the civil rights fight. Think about all the ways how long it took to buck break the South into not discriminating against black people. It took a long fucking time. It took a long time. Many years of lawsuits and many decades of lawsuits. So no, there's no easy way. If there was, I wish I knew it. I wish I knew what it was. Lars is saying, yeah, they refuse to even order ammo. They make you buy what they have. And he's saying, and the fees, if they do, are insane. It's like $100 an order. That's ridiculous. And I feel bad for you guys. I truly do. Yamal saying, what are the Reconstruction loyalty oaths? So Reconstruction is from the Civil War. After the Civil War, the South was under military governance. The states still existed, but there were military governors. So there were generals in charge of let me see here. Hold on, chat. There we go. Sorry. All right. So during Reconstruction, you had the Union in charge of your area. You were under military governance. You were just in an insurrection and you lost. So for a while after the Civil War, it was called Reconstruction, the Reconstruction era. And it went for a little while in American history. But yes, the South was under military governance. And it was a critical part. Reconstruction, like they call the 13th, 14th, 15th Amendment, is the Reconstruction Amendments. Generally goes till about like 1875 or so. So the 10 years after the war. And, here are the... Let me see here. I was going to bring up just so you can see. But yes, there were multiple, states. Like the states had military governorship, so you were stuck. But part of that was to engage in things. They made you, like you guys were just in an insurrection. There's a loyalty oath. I promise not to do all the shit we just did. I promise to believe in the United States and uphold the U.S. Constitution. Yeah, okay, that happened, but that was in the context of a literal fucking civil war. A guy who wants to just buy ammunition and arguing this is the same thing is a problem for them. So I hope that makes sense. This is the Reconstruction notes. Like Reconstruction was a pretty crazy time, especially right after the Civil War. The Union had a tough time of kind of reinstilling order in spots. Keopathic says 40. Dude, the default AUG magazine is 42. Okay, it's a 42 round magazine. I don't know. I don't use it, so I've never sat and loaded it. Jose is saying, yes, the federal court pretty much gave Puerto Rico constitutional carry for like a year due to ruling their previous licensing law to be unconstitutional. That was the same thing for the state of Illinois. Guys, many years ago, Illinois had, they had set up where they weren't issuing anything, and they had fucked around enough that the federal courts were like, look, you need to figure this out by such and such date or it's constitutional carry. And guess what the state legislature did? They immediately fixed it. And now Illinois, shell issue became a thing. Or was it Wisconsin? I forget. It's Illinois or Wisconsin. But either way, the Seventh Circuit's like, if you don't fix this, we're just going to let people carry guns. And they were like, oh, no. We'll fix it right now. We promise. And sure as shit, they fix it in a hurry. 10KV says the Puerto Rico is a possession, not a state. Does the Constitution really apply there too? Yes, it does. The Constitution applies on all United States territory. But that said, though, the territories, like Puerto Rico, the Virgin Islands, Guam, the Northern Mariana Islands, they have pretty fucking restrictive gun laws overall. So yeah, it's a little different. It's a little different there. But yes, they do. The Constitution does protect them there. Supposed to, at least. It's supposed to. Keep asking, if you live in SoCal and you go to Vegas, take Nevada 163 south of Laughlin and then the Needles, and you're in the clear. Now you know how not to break the law. Thank you. That's a very good advice. Okay, there you go. I know Needles is in California. What's the over or under on the Ninth Circuit finding a California spirit to rely on, the spirit of aloha in California? They might. We don't know. Given what's happened so far, like 50-50. A name of some sort says, how much it must suck for the CNR, and guys, that means curio and relic. They are people who collect, when guns are over 50 years old, the ATF can classify them as a curio or a relic. So a lot of the, pretty much almost everything for World War II is a curio and relic. So like an M1 Garand, Mausers, Enfields, Mosin Nagants, Arisakas. A lot of the older firearms are considered curios and relics. And with those, you can actually have those shipped to your home if you have a curio and relic license. So that's what CNR is. It's actually a lot of people have these licenses. He says, I wonder how much it must suck for the CNR collectors of Cali. I've never found 6.5 millimeter Carcano. That means the Carcano rifle that Italy had shoots a special 6.5 millimeter round, and 6.5 Swiss at a store. You mean 7.5 Swiss? Either way, they all have their own cartridge designs that might be similar calibers. I've never found 8 millimeter, 7.65 millimeter, 7 millimeter Mauser are seasonal at big stores for hunting season. Yes, a lot of these are very, you might find the cartridges at the right times. If you're looking, for example, in states where they have rifle and gun season for deer and big game, you're going to find in the fall, they're going to have a ton of ammo sitting around. Whereas during like the spring and the summer, all that's going to be off the shelves because nobody needs it right now. So yes, I mean, even for ammunition, it can be a seasonal and what you can find in the variety. And then Jose says it was Illinois. The holdup with Chicago trying to be placed outside the CCWs, like New York City's outside the state CCWs. Yeah, and then the Seventh Circuit said like, nope, it applies everywhere. And they tried to fuck around, and the state of Illinois got very scared very quickly. So it does work sometimes. The courts do the base things, but that was a long time ago now. And yes, it was in Illinois. Well, thank you for clarifying. Like I said, I kind of forget. And if it's not part of my state's lore, it's it's easy to forget in time. Easy to forget in time. Let's see where you guys are at. Distance says, beware the Cabela's at state line on Highway 80, on I-80. There we go. Weirdly, Sean is not a Seventh Amendment absolutist either. I can only fit so much in the Twitter profile chat. I can only fit so much in the Twitter bio. Yes, Ronald Reagan is the reason for many of the awful gun laws. Mm-hmm. In California, yes, he is. He 100% is. Let's see, what else are you guys talking about breaking the laws, basically smuggling ammo into California? Jeez, you guys. And Lars says, yes, they've doxed carry permit holders multiple times. Yes, that has been an issue in California. That is something I'm aware of that's happened multiple times. Let me see here. What else are you guys asking questions? It has. Sergeant Dormant says, my uncle has a high power, but it's scuffed as fuck. The sight fell off and he super glued it back on. Well, I mean, if it works, it works. Oh, if that super glue can survive the recoil, that's some pretty good super glue. Let's see here. Yeah, the territories get real wacky with gun laws. They do. Excited Utterance says, get this, Sean. Steve only worked out today. I am not a lawyer. We've been mates for over a year and somehow this topic never came up. Ooh, what? I don't get it. I'm confused. Who? What? What did you say?
He finally figured out what that meant, like that, what the initials is.
Oh, like Gosney only figured it out? I don't know. I don't get who figured out what initials. I don't. What? What initials though?
I am not a lawyer.
Oh, okay. I didn't know any of that, so I don't know what we were talking about. What initials? There are a lot of initials in the world. AD says anything before 1898. Anything before 1898 is an antique firearm under federal law. Curio and relics are things the ATF can designate after they've been around for 50 years. Now, the funny thing is, an AR-15 could technically be a curio and relic now because it's older than 50 years. Oh, Jordan says if you still got your CNR, you can get ammo and old guns shipped to your door. You still can? Okay. I didn't know if Florida that ruined that. Do I have a chrysanthemum Arisaka? No, I don't have an Arisaka. I have an Enfield, and I have an Enfield number 1 Mark III. So I have a World War I Enfield. Yes, early AR-15s are CNRs now, yes. Would an MG43 be a CNR? You mean an MG34? Yeah, you can have like automatic weapons, but they're automatic weapons, so they're in their own class. That doesn't really, they don't get CNR'd, so you can't have machine gun shipped to your house. Porcelain Thunder says, my 5-inch naval guns are relics. Yeah. AD says, what does CNR stand for? Like, are you like, well, CNR stands for curio and relic. Are you talking about like in property terms? Like, because it's just CNR. But are you saying like, in regards to that, it's like in a property context as a whole? Well, cleans. Do you mean like CCR, like Clean Clearwater Revival? Because that's the only other thing I'm thinking of, unless you mean like in the legal sense, that means like covenants, conditions, and restrictions. Like when you buy land, you might have a list of like covenants, like there's a list of prohibitions and things attached to your land already. Who the hell's outside? Oh, well, I just get their headlights are flashing. That's a separate thing. It's like when you buy land, a covenant, condition, restriction, your CCNRs will be attached as like, here are easements, here are covenants. There's a covenant already on the land from an owner previous that, nobody can build a barn on this. Nobody can do agricultural stuff on this. Nobody can do X, Y, or Z, or there's conditions on the land, all kinds of stuff. That's a different thing. Let's see here. Let me see here. What do you got? Hold on. I'm trying to catch up. Blue Loctite is what keeps on Glock sites. Yes. Oh, Gosney only learned today that Hell is not a lawyer. Ah. Okay. Thank you. I had to yeah, there we go. Yeah, it was really confusing. I didn't know what the hell we're talking about. I just didn't know what the fuck we're talking about here. Ian McCollum should work for the ATF. No, I don't want to do that. Yeah, machine guns are outside the CNR. It's like, you like, even if you tried to classify a machine gun as a curio and relic, the problem is it's still a machine gun, and the machine gun laws are the paramount. And like, here's the thing, Chad, if you don't understand, the machine guns are the top of the mountain when it comes to any sort of restrictions, things like that. When it comes to NFA items, period, the NFA status of a gun takes precedence over if it's like a curio and relic or any other ATF designation or federal designation for it. So once you're in the NFA, that's the top of the mountain. And then the tip top of the mountain is machine guns. The machine guns are like the king class. So it doesn't matter what you do with it. Oh, it's a CNR. It's still a machine gun. Oh, it's a CNR. It's still a destructive device. You have to worry about those things. And if it's a destructive device that's also a machine gun, it's a machine gun. Like, the machine gun is always the top thing. Benito Salazar says, I miss the $100 Mosins. I feel like a chump. I mean, yeah, the $100, $70 Mosins. I remember being in high school and it was like, buy 1,000 rounds of ammo and you get like an SKS for free. So yeah, there was a time. There was a time. J-Rock says a lot of chat may not know federal gun laws. I know, that's why we went through them. Some states with NFA bans exempt CNR guns. I didn't know that CNR guns would be exempt, but there are many states with NFA bans, like California. Pretty much everything's banned. Washington, I think SBRs and short barrel shotguns are banned too, but like, you can have a destructive device. But yeah, states could ban all kinds of stuff. They've been getting away with it for a long time. J-Rock says, Sean. Yes, that's my name. Nero says, does it have to be manufactured before 1898 then? Or do replicas meet muster? It depends what you're like, in what way you're doing it here. So, if it's the part of the idea that it's a curio and relic is ammunition is not readily available for it or may not exist anymore. So if you took a curio and relic firearm, but like you rechambered it for a modern cartridge, well, it's no longer a curio and relic. So reproducing them kind of becomes an issue because you're likely to reproduce it in a situation that it's no longer a curio and relic anymore. Because otherwise you don't really have people generally making curio and relics that are, not exist, like with non-existing ammunition supplies anymore. I mean, they mean explain what curio and relic means. Well, I did. Is there any Torgo the White saying, is there anything the Trump DOJ could do to the states, lawfare, to get them to stop fucking around with this stuff? Yeah, they could. The DOJ could start suing them and saying you're like, seriously, and I'm not joking, they could. Just like with the Skermetti case we watched the Supreme Court oral arguments on. The DOJ's like, you're discriminating against the heckin' trans people. The DOJ could turn around and say, hey, you're discriminating against gun owners. Stop. They could do it. They could do it. Is it going to get you anywhere? Probably not. Probably not. I don't think it'll get you where you think you're going to go. But the DOJ could do it. Then, like I said, it becomes a question of, will they do it? And I don't think they will. I don't think they will. Why is this such a weird? Why is this such a weird thing there? There we go. A little, looks so weird when I'm all scrunched up on there. So they could start doing that. The DOJ could start suing California, Washington, Rhode Island, Connecticut, Massachusetts, Maine, Illinois, Wisconsin. They can start going after everybody but it's not going to happen, sadly. Let's see here. So also happy Friday the 13th, chat. Yes, distant. I remember those days too. The tins of 7.62 by 54 Russian, with the rims, the rim cartridges, 440 rounds for $60, all gone. The spam cans are gone. All federal gun laws are criminal, pretty much. And Balm says Minnesota only allows machine guns if they are CNR items. We'll see, and that's kind of the time, guys, where there are things where it overlaps or is important. But generally, for the most part, if your state bans machine guns, it's a general ban. But that's interesting to know. So you can own like a potato digger, a Colt 18, and for people in Minnesota, that means you're restricted to like a Colt model 1895, a potato digger, probably some of the early Maxim guns. There's very little you're going to be able to own. Let's see here. AD says, do you think the CEO killer gets federal charges? No. I mean, I don't think the federal government, like, they could charge it for using like an NFA item in the commission of a crime, but I don't think that's going to happen. They're going to be like, look, New York, you can handle it. Prosecute him, put him in prison forever. He'll spend his days at Sing Sing. Jose says Illinois only allows NFA if it's CNR. Interesting. So you got to have like a CNR short barrel, like, so if I have a short barrel shot, if I have like a old Browning Model 5, Auto 5, I can make that a CNR. Or have like an Ithaca Auto Burglar. That's interesting. I thought it was a complete NFA ban there. Yes, you need to donate 95 subs. That's not a bad idea, chat. Pray this gray away. There's a lot of gray in here tonight. Logical Bystander says, would you ever watch and react to sovereign citizen court stuff? I would. The thing is, like, there's a lot of stuff out there that's already, I think I've reacted to some stuff once or twice on the member streams. But yeah, I'll do it. I mean, if you guys would really like that, we can set some of that up one night and watch a bunch of it. Sometimes it's good. Sometimes it makes you just want to like figure out if you want to take one of these and just like shove one of these through your eye sockets. But yeah, if the funny stuff is out there, it's pretty good. You just buddy. And Baldwin saying if I was president, the DOJ would be doing stuff. Yeah. Well, that would be really good, but like I said, I don't think it's going to happen. I wish it would, but it's probably not. Distance says I have a few spam cans left of 7.62 by 54, and they're worth north of $300 now. Oh, I can only imagine they're worth so much. 10K View says, should the DOJ be obligated to go after these states? Yeah, I think they should. I think they have an obligation. Currently, how the constitutional law is seen with the 14th Amendment, all incorporating it. Yes, they should have an obligation to help defend the citizens of the United States anywhere constitutional rights are being infringed on. Sadly, though, that's not going to happen. But yes, I think they should, and I wouldn't be opposed to that because we've already got the DOJ being a lawfare arm for how long now? Decades and decades and decades, where it's like, look, you can actually go do some effective stuff. And they're like, but I am tired. So yes, I would like for them to go do it, but they're not going to. And the other thing is, let's say Trump's done and like Vance doesn't win, and immediately a Democrat takes over, the DOJ would immediately stop, and that would all get fixed. Ricky frickin' tick. But yes, I would love to see that happen. I would love to see Elizabeth Prelogar being forced, the Solicitor General, and being forced to argue for the Second Amendment like that. I mean, that would be a phenomenal thing. That would be a phenomenal thing to happen. Fallen Preachers, wait, the potato digger, is that a Ginger reference? No. And we'll talk about it in 1 second here. Let's see. We're going to start that and come back to it. In the meantime, um, 10K of you gifted 20 subs. 10K of you says, I want to pray the gray away tonight, chat. Gifting 20 memberships here, chat. Thank you so much for the support and your generosity, 10K of you. Thank you very much tonight. Getting rid of these grays. Grays, keep moving. This is a green neighborhood only. Jose is saying the ATF can declare specific guns CNR regardless of age. Yes. Yes, they are. They can. I will say this much, chat. There are a lot of exceptions to what in here. Like I had to give kind of like a presentation once at a local bar association when I first got out of law school, and it was about some gun law stuff. And I said, all the ATF rules and policies are, I'm going to speak in generalities because there are literally like a million exceptions to every rule the ATF has. Every rule and policy has a million exceptions. Every rule and policy. There's entire, like there are so many things out there that the ATF has. Like the CNR list includes specific firearms. The ATF, I believe, on the there's just so much they do that is heavily just pointed out one way or another. And then they have a million separate times where they just don't, they do whatever they want. And they say, okay, well, this doesn't count. Why? Because we said so. Like there's a million exceptions. And any ATF category you start looking into, it's a very common thing that happens. And yes, the CZ82s are CNR, even though new manufacturing, because the West Point Museum requested it. Yeah. And that's the thing. They will do all kinds of stuff like that. And I forget if it's the CNR thing or it's this thing where there are specific guns listed by serial number that are on an ATF list of approved weapons. And I think it might be like that meet the CNR standard, or there's something where specific guns, because of their you might know what I'm talking about, Jose. There's like an entire list of guns and it goes by categories. And then at the end, if you keep reading it, it's like, blah, 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 serial number, boom, 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 done. Like a specific gun is referenced by the ATF. The ATF does, you've heard me mention it before, chat with the machine guns. The May 19th, 1986, with the Hughes Amendment is got a big asterisk after it because there's so many things, the exceptions after that the ATF has done. And there's a million different paths you can go down to. But generally, yes, a gun over 50 years old is eligible for CNR designation. But the ATF still has to classify it as CNR. Being 50 years old doesn't automatically make it CNR. So, yeah. But yes, the CZ82s are new, even though the West, yeah, that is one. New York is only charging second-degree murder. That's interesting. They're not going after him all the way. Well, let me go over the Elizabeth County lawsuit. Yes, I want to. I think it's hilarious. It's hilarious. You know a lawsuit's good when the attorney who wrote it puts himself into it and cries about it. I'm black-pilled, sadly. I mean, do you want me to lie to you and say it's all going to be okay? I don't sell copium, chat, and I don't sell hopium. You got to go somewhere else for that. Alfox saying, I sent you a semi-soft-sit jailhouse lawyer of a guy called Lane Myers. We'll take a look at that. Porcelain Thunder says he better not get the Riverview cell at Ossining. And guys, Sing Sing is the name of the prison, and it's at Ossining, New York. And that's up the Hudson River from New York City, not too far. And then Jose says, you don't seem to mind my gray money. Or is that my gray tax for being allowed to live here? First of all, lower your voice. Yes, thank you, Jose. I appreciate it. Oh man, that's funny. Yes, that's your jizya. Yes, I'm like the Muslims. I force you to pay a tax to survive here as a gray. And then Ducky Fuzzer says the feds can pull funding from the state to force legislation like they did for speed limits and seatbelt laws. Yes, and the drinking age. They could, but that's not going to happen here. It's not going to happen here. So, and also I don't want federal gun laws getting out there because remember, chat, gun laws are scary, like a national CCW. I mean, it sounds good, but that sounds like that can get fucked with very easily. Passing laws is a dangerous thing because passing laws just whipsaws back and forth. A court ruling is going to be more effective, I would argue. Now, getting back to Fallen Preacher saying, what is the potato digger? All right, we're going to talk about this real quick. We're going to do a Wikipedia article. We're only going to show it off the corner of the eye here. So it is this thing real quick. We're going to show it. It's the model 1895, the Colt Browning potato digger. And it was called the potato digger because when it operated, the operating action, normally you think of a machine gun, it's all internalized. Well, the model 1895, that was back when we were still people. John Browning, one of the most prolific gun designers ever, he made a bunch of different guns. Just like with the Gilded Age, and the pre-World War I age, even into World War I, we were still figuring out what is an ideal way to make a gun. It's like you had the Luger with a toggle lock action. There's a reason why after the Luger you never really saw that. Okay, and the Pedersen rifle included. You don't see toggle lock rifles being manufactured anymore. Why? There are people developed a better mousetrap than that. So the potato digger, when you'd sit there and you'd like bop, 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 you're shooting it, there was part of the action would cycle, like you'd see it come flying down below the gun. And the idea was if you had the machine gun down on its tripod, down in the dirt, it would dig a trench like a potato digger. So that's why it's called a potato digger. And like I said, I can't show you more of it than that, but it had a part down the front of it that operated down below. And okay, here you go. Here's a good picture of it. See this thingy, chat, right here? That dingus, the operating lever, the operating rod, the operating mechanism extending down. Imagine if that was all the way down in the dirt. It would be digging trenches, like it's digging for planting season. So that's why that's there. That's why they call it that. That's why they call it that. Jose saying, yeah, the serial number list is about World War I and II pistols. Yeah, it's okay. So the Browning High Power for a long time was made with a wooden holster that doubled as a stock, and you could slap it on the back. There are guns that you are allowed to play around with that are exempt from the National Firearms Act. So they're not a short-barreled rifle anymore. Like if I tried to put a stock on my Glock pistol, that's now a short-barreled rifle. But there are guns that have exemptions. And I think there's another class or two or another thing or two that has exemptions, and I forget. But I think you're on the same thing as me there. It's hard to remember. It's hard to remember all the shit that's out there. And then the 10K view with 10 more sobs. He just grays. He's like, I'm praying you away today. He got down on his knees, chat, and he's like, God, Lord Jesus Christ, please get rid of these grays. Please get rid of these grays. So thy will be done. Thy will be done, chat. Remember, do your part to get rid of the grays here. Convert, everyone. Convert the infidel. Thank you, 10K. I appreciate it. Yes. Can we hit the goal? At AD is saying, why is the CEO killer only charged second-degree murder? They felt that was proper. Prosecutorial discretion. I don't know. Logical bystander says, stop the forceful transition to grays. No, you must suffer. We're transing all of you. You're all getting transed tonight. All the grays getting transed. Sean said this is Grove Street. Was this local bar association called Stonies? No. You only become green by being a concubine of Sean. Yeah, well. The CMP used to be able to ship a door straight to your door in M1 in California. Yeah, apparently people are saying that you can now with a CNR. So, and besides, I never got an M1 Garand in the CMP for a while. I lived like 30 minutes away and I never got one. I'm kicking myself because they're all fucking garbage now. But I might try to go buy one soon. I need to. P-Dub says G Series fouls. G Series fouls are a kind of a thing that, yes, got special ATF exemption. So Ian McCollum's talked about this, but I learned this many moons ago because I got the chance to see one back in like 2008, and it was a foul and it was worth like $5,000. And I was like, how is a foul worth $5,000? So back during the early imports of the Fabrique Nationale's Fusil Automatique Légère, the light automatic rifle, they were imported as semi-automatic weapons. The problem was FN, when they cut the receivers, because in FN foul, the receiver is machined. It had cuts in it to accept the full auto components, but it only had, they basically shoved semi-auto guts in it and called it good. Well, nowadays you can't do that. You have to make the rifle specifically designed for semi-auto fire only. That's a reason why in AR-15, you cannot take an M16 fire control group and jam it in there. It will not fit. You have to do a bunch of things in the back, like milling out the back and creating shelves. You have to do a lot of you have to do some machining work. And then you got to put a hole through there for the third hole of doom. Things you have to do to convert it. Well, the G Series FAL, you can literally take automatic parts, drop them in, and it will be fully auto. The ATF found out about this after they got imported and said, okay, they're exempted, but it's a specific range of FAL receivers are exempted under ATF edict. Now, theoretically, they could change their mind and revoke this, but they're known as the G Series FALs. And they're a collector's item. They're a collector's item because of that. It's provenance. It's just like a piece of art. It's got provenance now. It's a very rare thing. So they're out there. I've seen one. I've held one before. Pretty cool stuff. No different than a regular FAL when you hold it. It's just it's got special dispensation from the federal government that it's technically a machine gun, but nobody cares. Like, it's not treated like a machine gun. So... Oh. Oh, Ducky Fuzzer, we already did that one. Kayla says, New York only does first degree for murders that would get death in other states. Yeah, and I'm sure what he did here would get him the death penalty in many states. He'd be eligible for aggravated murder in Ohio with premeditation and planning. Like, it certainly could. It certainly could. But, okay. That makes sense, though. I appreciate that. But I give out black pills for free. Well, it's the jizya tax. Yes, the jizya tax. I left early today. Did you cover Matt's case? No. I plan on doing that tomorrow because we need to cover that. There's been some updates in that are interesting, and we'll get to those. And actually, well, yeah, hold on here. Let's see, what are you guys talking about? The operating dongle. Yes. I mean, it's basically what it is. Oh, no, it can't help us find Mama JF. It can't help us find Mama JF. No, it's gone. She gone, chat. A name of some sort says, I've never heard of stocked high powers. Do you mean C96s? No. Google Browning high powers. They came equipped for stocks. I mean, Google, start Googling Browning high powers. They got Browning high powers with artillery Luger style sights on them. Ridiculous, marksman style sights. And yeah, there were many pistols that had it. So it's not just a C96. The high powers were famous for this way back in the day. Jose says if the USA ceased tomorrow, what would be halal in Ohio? In Texas, we would instantly have over-the-counter machine guns. I don't know what would happen in Ohio because our governor is a communist little troll and an establishment Republican. So I don't know. If the U.S. government ceased tomorrow, though, I'd be doing whatever the fuck I wanted anyway. So, that's what I will say. Neo Dark Matter says dodged. Great for life. Maddie B says the M1895 is only known because of how crappy it was. Well, it kind of worked. It worked good enough. Renal MD says, how does one get a CNR license? Is it hard? No. You apply through the ATF. Although if you live in New York, I don't think CNRs really help you at all. I think in New York, you would want to find out if it's even worth the time. But it's called a C&R, Curio and Relic. You get a Type 03 federal firearms license, and it allows you to have things to your house. But you do have requirements. You basically have to keep a bound book. So you're just like a regular gun store. Like all the stuff that comes in on that license, you have to keep what's called a bound book, and that's what gun stores have to have. You're subject to audit. Now, they can't just show up at your house, but they give you notice. You're subject to audit. You're subject to compliance. So there are advantages, but there's also, you got to pay the piper sometimes. So that's, is it public or private info? Well, you can't, a newspaper can't necessarily divulge it unless you have to divulge that to your local state license agency. So it's the government, reporters can get a hold of it, but I've never heard of them publishing CNR information. So Swissgar says some AR-15s have a full auto shelf and pocket. Yeah, but generally speaking, you aren't just mass producing those. The ATF won't let you do that. Manny B says, I don't know why they call it the third hole when it's technically the fourth hole. Well, the third hole of doom is more of an AK thing, but it also get put onto anything where you have to put another drill hole through. Jose says, I know a guy in Canada who got the MG2 semi-converted SIGs accidentally approved for sale. They gave him a machine gun license, but he was still cucked to 5-round max. Really? That's funny. You have a fucking machine gun and, you gotta reload every fucking 5 rounds. That's awful. That's awful. KLF says the jizya, is that one of those dem facials? No, that is the tax that Muslims will impose upon non-believers to practice their religion. So if a, radical Islamist came into your area and you wanted to go to church, he would make you pay a tax, and that was tax you were allowed to then go pray. Jim, how you doing? Jim says, are you going to cover the news out of Texas, Riley and Eric July? Yes. Do you have documents? Because that's the thing I need, and I haven't had a chance to go find them. But yeah, I'd like to take a look at them and see actually what exactly it's all going to be. I mean, I know it's going to trial, but I don't know a whole lot more than that. I mean, I know all the shit that's happened online, but what are the actual documents that are out there. So if you have them, I'll take a look at them. But I haven't done, but that's all I know about it or can do about it now. Will you cover the Mercanti lawsuit? I think I said yes, but yes, I will be. There's a lot in there to cover. It's fucking hilarious. It's really pathetic too. Wasn't there a quadruple murder here in Ohio a few days ago? Yeah, there was. I saw that. It's fucking crazy shit out there, man. Fucking crazy stuff. How you doing, by the way, Eric? Hope you're doing well, man. New York Renal MD is saying, ironically, I'm in Cali. I'm in a New York OG. Okay. So you went from one dumpster fire to another dumpster fire. Are there any firearms restrictions you support, Sean, or should it just be another commodity at market? I mean, I would argue you do have the right to prohibit, like if someone's on probation, you probably can prohibit them from possessing one. But other than that, generally not really. If you want to own a freaking Tacoma with a Dushka in the back of it, great. You know, if I'd love to own like an 60 millimeter mortar. You know, I'd love to own a Javelin missile. Yeah. No, I really don't have any, it shall not be infringed. There's really no rules. And, you know, if you're dangerous, you hurt people with it, we already got laws for it. Jim is saying the case got dismissed. I didn't know that. Huh. Riley's case got dismissed? I didn't know that. That's cool. Then why was it? I thought it was set for trial. That was Dick was like saying everybody's going to trial. Oh, we threw it out today. Okay. I had no idea about today. So that's interesting. I didn't know anything about that. Fruit Fly says unique consent for what? Not sure what unique consent for. The surreal goose for $5. I love this. I love that meme with the goose was like honk. The big fan of drilling the third hole, am I right? I mean, just a little bit. I mean, I'm not gonna say I'm a big fan of drilling the third hole, but you know, it's kind of like one of these. I'm just saying that's yeah, just whatever you do, chat, do not follow these instructions. This is for setting up your deck patio, setting up your patio, in your pool. Definitely don't rely on this. What the hell would I do with a Javelin missile? I don't know. I don't know what I do with a Javelin missile. I want one. That's the point. That's the point. Okay, so there's a motion hearing the judge quash the case. Yeah. Don't javelins use some amount of radioactive material in the ordinance? No. You're thinking of depleted uranium. But that's like very small amounts, and the uranium's only poisonous if it's like you're eating the uranium dust because uranium was considered pyrophoric. It shatters on impact and it spalls, and that dust that it creates, uranium dust, is kind of like grain dust. It's very highly flammable, and that creates problems. So unless you're sitting there like eating up uranium dust where you're getting like heavy metal poisoning or like eating chunks of depleted uranium, it's generally not a risk to people. Rest in peace, Sandwich Man. You'll be missed. There's nothing wrong with that. This is just all for academic purposes. What is 1.25 in normal world units? Isn't that like an eighth of an inch? 0.125? I think. Yeah, 0.125 is a fraction, is 1/8 of an inch. This is in American. This is not metric. So, Bob, yeah, that's a 1/8 inch hole. But you're doing it just shy of an 1/8 inch down, and yeah. If you drill this hole, You know, this hole and all this is how you set up to do. This is where the safety goes, chat. This spot right here is where the safety goes. And that big hole is the safety. And that's how you install the auto sear. Those are the holes you drill. And some of these holes are already there, but it's, like this. That's why you see like the 3 of them that are there. And then you have the little hole. That's how you set up for an auto sear. What's with all the questions? Yes. Why are you guys ask too many questions? You guys ask too many questions. New York Renal MD says does wonders for the local population with depleted uranium. Yeah, well, they already, there's heavy metal poisoning possible. Yes, if you're sitting there and living in it, yes, it's really bad. But if you're not like playing around on like the uranium dust, you're probably going to be okay. You disagree? Depleted uranium poisons the environment it's used in. I mean, somewhat. But we have, yeah. Jose says easy as 1, 2, 3. Yes. And whatever you do, chat, don't build a lightning link. This is a lightning link. Whatever you do, chat. This is the bottle opener part, and down here in the bottom's the tab that goes in the slot. Yes, it's all for inquisitive minds, chat. Inquisitive minds. Oh. Yes, it's in freedom units. Oh, I can't wait to build my porch. Oh boy. That would be really funny if somebody did like get their concrete poured for their patio and their pool and it was poured in the shape of a lower receiver. That would be hilarious. Yeah, don't draw a card and sell it. That's for sure. Yes, definitely don't do that. Jose says, how would the PLA work for the bottle opener? I don't think it would, because remember, when you have a lightning link, you have that metal part that sticks up like this, and it's getting beat on. I think that stress would waller out the hole. If you're going to do anything PLA related, you'd want to do the Swift link anyway, or the Yankee Boogle, and print that out, because that's still going to get worn down, but it would be probably far more durable overall. I just don't think PLA, even like really anything, even resin, the force on the when the carrier is smacking into the lightning link, it's pretty rough on the lightning links. Like if you like back in the day when people invented the lightning link, the idea was is a piece of, you could throw away metal. You'd take it or you'd smack it on the back. Like you'd take like a hammer, like you have like a hammer in your gun kit, and you take a hammer and you fucking flatten it back out and shove it back in the gun. So let's see. Bent killing or what? Yes. Lightning links were meant to be consumable. They were 100% meant to be destructive, and they wouldn't last forever. But yeah. Now Jose says, does the Baldo fit on the potato masher behind you? I don't know, but I will tell you, Jose. I'm looking at doing the Odin 40mm launcher. I did some looking around the one night we were on locals. The Baldo's roughly like 39-ish millimeters in diameter. So you could launch a Baldo out of a 40mm launcher. Or if you sanded one down, you could probably do one out of a 37. But I think it's more funny to use the Baldo, like with the Baldo work as a less lethal round. So like load one of those up in an M203 and like launch it at things and see what happens. Launch a Baldo at a Baldo, shooting down the Baldos. JB says now they're a $20,000 piece of sheet metal with a serial number. Oh, they're far more than that, I think. Hold on here. The machine gun price guide, I think, shows in chat. I know we've looked this before here, but we're going to go back to this. Hatstrick says, how did you measure a Baldo? I Googled it. I went online and was reading. If you go on the Baldo website, you can read the specs on it. People have done some specs on it to do it. So that's how I learned about it. Anyway, so we need this is, if you guys ever want to know, machinegunpriceguide.com kind of gives when people are reporting how much guns are selling for. So we need machine guns, we need auto sears, AR-15 Lightning Link. So back in January of 2008, you could buy an AR-15 Lightning Link for about $6,000. Fast forward to December of 2023 when this was last updated. Oh, it actually is under 25. I thought they were like 30 at the time, but yeah, you're $23,000 for a piece of fucking stamp metal. And if you guys don't know what a lightning link is, a lightning link is literally a little piece of shit metal. This is a lightning link, chat. Here it is. Hold on here. If I could find a good thing of one. Put together. Where is one? Oh, here we go. This is a lightning link, chat. This is all lightning link is. About this long. About that long. About this wide. And then about this tall. That's all lightning link is. That's all it is. Yes, they make link protectors and you can make new paddles. Yes. Yes, you can make the vertical part, you can make new pieces of. Stephen Cooper gifted 10 subs. Stephen, thank you for helping keep this a green chat and praying the gray away there. Thank you. Thank you very much. We appreciate the support and the generosity. JB said, I bet you could build a Baldo launcher out of a scaled down spud cannon. Yeah, you probably could. I'm sure that you could find PVC pipe that's 40 millimeter. I mean, that's not too hard. I've thinking about wanting to do the 3D printed 40 millimeter launcher anyway. I think it'd be a lot of fun. And why not do, if I'm gonna go the full distance, have a registered 40 millimeter grenade launcher, I'd shoot a fucking Baldo out of it anyway. Because it'd be funny. It'd be funny and weird, chat. Oh, Angela, you just learning it's a dildo for your balls? Yeah, it really is. Oh. Let's see, what are you guys trying to catch up on here? Does the Baldo measure 40 millimeter roughly? It's like 40, it's like 39-ish, 40 millimeters in diameter. So, yes, it's so funny and weird, Charlie. So funny and so weird. All right, chat, where are we at here? Yeah, that's kind of, I mean, could you use a lathe to narrow the Baldo if it didn't fit? I don't know if you could. I don't know how well that like silicone rubber would machine. You're probably better off sanding it down. Stacy says, what is that in freedom units? What's 40 millimeter in freedom units? It's like 40 millimeter in inches is 1.57 inches. 1.57 inches in diameter. Where's Trump? Oh, I had hold on, I gotta grab him. Forgot. Yeah, he had to take it down. There you go, Donnie. You're back up. All right. So when I got a call from a juvenile court this morning. They're like, "Hey, Sean, there's a shelter care hearing. Like, Children's Service had to remove some kids from a home last night. We need somebody. Like, can you represent a parent on their hearing today?" And I said, "Sure. I can't be there because I'm like, I can't make it out there. I have stuff to do today, but I can do the hearing virtually. So I did a Zoom thing, and the way the Zoom blurred it out, you could still tell there was somebody back here. So I had to take him down and lay him down on the ground because I didn't want, like, you're not, like, the idea is you don't have other people in the room. Like, if they're your attorney staff, fine. But you could tell there was somebody back there, and it looked like there was a real person standing there. So I had to take him and put him down when it was blurred. Angela's asking, why do you need a ball dildo? Does it enhance sex? No, it's basically because your wiener doesn't work. So that stands in for the place of your dick. And Stacy says it's 1.5 inches wide. Yes, diameter. Not circumference, diameter. 40 millimeters, 1.5 inches wide. Has chick says checks a ruler. Oh. Maddie says you can make an SP1 carrier from an M16 carrier if you use a grinder. Why would you do that to your M16 bolt carrier? Those are like the best. That's the gold standard. You want a full auto bolt carrier. It's got more mass in it anyway. Enhances reliability. An AR-15 bolt carrier is not as good. And then you could be really stupid and make a Colt style bolt carrier where you cut the whole back end off. And I'm like, that's just garbage. Jose is saying, remember it has to be a first generation Baldo. Nick said the second one got softer because too many people complained about it locking onto their balls. So the first gen's armor piercing, the second generation's too soft. I'll keep that in mind. Oh. Yeah, well, that's what I mean. Like, I was serious, like, where's Trump? And I'm like, I don't know, fucking Mar-a-Lago? He was in France. Like, I don't fucking know. I'm like, oh, wait, you mean the Trump thing? Like, I'm like, yeah, I get it. Took me a second. Took me a second. Do I use the cat filters on Zoom? No. Let's see here. The second gen is like a hollow point. Yeah. The M16 is not correct for a GI sear. The AR-15 bolt is cut not to work with any sear, and the SP1 is in the middle and works with lightning. Like, yes, but then you also have the Colt later on where they make the bolt carriers where they cut out the back half and they milled out the whole thing. But a GI is the correct for the GI sear. Yeah, I know, but that's why I have, like, in my guns I have full auto bolt carriers. They enhance the reliability, I believe, at least, and I like the enhanced weight in them. And that increases the reliability. Put Trump's hat on, Sean. I use the Clyde filter at Zoom. No, but every once in a while, Laney or Clyde starts borking, and you can hear him through the door, and it's it's disrupted the hearing once or twice. Stephen Cooper says, or you could buy Colt full auto fire control parts at an auction, allegedly, hypothetically. There's nothing illegal. Like, you don't have to buy them questionably. Like, you can buy full auto M16 control parts. You can buy a full auto fire control group right now. Having it all together in one place, though, kind of gets the idea of constructive possession. So yeah, I would never recommend that. But let's say you didn't own an AR-15 and you own the full auto kit. Okay, that's not a problem. Or if you owned, let's say, the full auto kit for an AK-47. That's not an issue either if you don't own an AK. So like I said, guys, playing those games, though, I generally don't recommend any of that. Don't play those games unless you really know what you're getting into. Yes, Israel did attack American sailors on Liberty. Yes, they did. 100%. Maddie says, we all have full auto carriers. Yeah, but, like, there's a difference between an M16, like, you know what I'm talking about, right, Maddie? You understand what I'm getting at, right? The different variations. Because that's all I'm trying to say. Like, there's a semi-auto carrier, and then there's a full profile carrier. That's all I'm trying to make the argument for, is that there is a difference in these. I mean, you guys didn't know, this is what we're talking about here. So these are the differences in the types of carriers you can find, bolt carriers. And this is the thing that carries the bolt. And then this big thing is the bolt carrier group on an AR-15. These are actually upside down. That they should be sitting right side up. But if you notice on these, the big thing is this part here in the back. On an M16 bolt carrier, you have all that. In an AR-15, you have just this little bit. On an SP1, you have just this little bit. And then Colt, when they were trying to be like during the 90s, they completely milled that whole piece off, so you can't trip an automatic sear. And as you guys notice, these are differences in this. This will trip the automatic sear in work. Now, if you don't have an automatic sear in your rifle, this is just extra mass, and it does enhance reliability, I argue. Some people say it doesn't. An SP1 is designed to operate a lightning link, so if you have a lightning link, you should use this. But otherwise, I use, if I bought a lightning link, I would buy an SP1 bolt carrier. But in the meantime, I just run M16 bolt carriers. Maddie says they stopped using the AR-15 cut carriers when the ATF said it wasn't a machine gun part. Yeah, but I thought that was Colt doing that. The way I always understood the story was Colt was kind of like anti-consumer and anti-gun for a little bit, so they were fucking with people. Because everybody else still did it. Everybody else still made you still got AR-15 bolt carriers that didn't have that machine off. That was just Colt being gay. What do I think is going on with the drones? I don't know. There's so much. The drone thing is so fucking weird. Like, the guy got caught. They caught a Chinese guy flying drones over Vandenberg Air Force Base, where we launch fucking missiles. And also, like, there are ballistic missiles there. Like, there's just so much of it so fucked up. And yes, this would be correct, Hodor. Yes, if you had a flat cannon, like an 88 millimeter flat gun, he could shoot down drones with it. California just certified their election results. Okay. You can't see the mouse. Yeah, weight does equal quality. Well, I mean, if that's the case, I'm high quality. Nothing but the quality. I have a full auto bolt carrier. Yeah. Yeah, Colt was horrific. They had a weird lower cutout too. Yes. Colt is actually kind of cool now that CZ owns them. Yes, but if you guys didn't understand, Colt Firearms Company had a really shitty, like, people didn't like them. They were kind of dickheads the way they did things. And for a while, Colt actually had the technical data package, all the spec'd out things for the AR-15 and the M4 carbine, because the M4 carbine was made in Colt. Colt was the manufacturer of it. In fact, there's a guy I remember, he told me when he was in the Army, he said he referred to himself as a paid Colt carrier. He was paid to carry a Colt rifle, and it was an M4 carbine. So Colt had those, and they had the technical data package, and nobody else had it because the military gave it to them, because the military is like, here, you're going to manufacture stuff. Well, Colt held on to it after their contract ended in the late, like after Obama got in. And Colt was starting to fuck around, and the military's like, give it up. It's not yours anymore. It's public information. And that's why there's been a blowing out of AR-15 manufacturers, because the technical data is everywhere now. And we know all the technical data is correct. Let's see here. The German government gave all the G3s to the Kurds and then sold them on. You might find them in Middle Eastern countries now, yeah. Emal says, the Second Amendment thing is a kind of Gamergate. No. No. But it's got its own intrigue. It's got its own intrigue in the gun community. It's got its own kind of intrigue there. It's got its own kind of lore. It's got all kinds of lore. Like I said, when you deal with the ATF, you deal with like the machine guns. You learn about like the Stempel M60s. You learn about all the different companies that existed, like the Sendra lowers that are out there. You learn about all the different things that have happened throughout time and with gun companies. There's a lot of cool stuff out there. There's a bunch of G3 kits in from Germany. Yes, but the actual import right now are the Portuguese G3 kits, which I really need to get my hands on one. I need to do that. They're kind of expensive. I'm hoping they go down in price because they're kind of fucking expensive. Yamal says, are there no woke firearm manufacturers yet? Well, there's not necessarily woke firearms manufacturers, but there are companies that are known for having shitty customer relations. Heckler & Koch, HK. They make the MP5, among many other guns. For a long time, the joke was their motto was towards consumers, you suck and we hate you. Meaning you as a consumer, you suck and we hate you. They made a handful of pistols and they basically told consumers to fuck off. So that's kind of where things are with things. They're getting better now, but for a long time, H&K was real shitty towards consumers. And that was the common thing with a lot of European companies because they were obsessed with military contracts only. And to be fair, like the U.S. gun market is got money, but it's nothing compared to what governments will spend on shit. So, Yamal's saying, do they only want to sell to governments mostly? Yeah. Yeah, government contracts are where it's at, man. You make more money doing that than selling to people here in America. I mean, shit. The average American gun owner's taste in guns and, how would you say it? The average American gun owner buys a lot of shitty guns because they're cheap, and the average gun owner is very fucking cheap. So making quality weapons is not a great way to make money here in America. Yes, I can't think of a firearms manufacturer that hasn't pissed off its consumers. And that's true. That happens all the time. What happened in Liberty Safes is a great example. Bill Ruger from Sturm Ruger. Yes, for the Ruger, the P95 Ruger, the P90 Ruger, the Ruger Mini 14. Bill Ruger was very, he supported the assault weapons ban and was like, you don't need an assault weapon. Bill Ruger was a piece of shit. Yes, he was really bad. Yes, he was a really bad guy. Sergeant Dormant says, I hate how gun tubers clickbait all their legal videos. I agree. That's why I don't do it that way. And Armed Scholar, where everything, the Supreme Court's always on fire. Biden's always grabbing things. NFA defeated. No, it's not. I hate that shit. I hate it to my core. So. Patty's saying, is the HKMR 762 worth the price? No. I mean, if you want one, yeah, I guess it's worth the price, but buy a fucking, buy an, for that kind of money, buy a fucking SR25 clone or something, or make an SR25 clone. Hell, it sounds like the PSA Saber is actually not a bad deal nowadays. Like, you'd be better off buying that shit, I would argue. Ruger, yeah, was very anti-high capacity magazine. And Yamal saying, is there a chance Ruger wanted to sell more handguns? Maybe, but Bill Ruger was just an asshole. Thoughts on binary AR triggers? They're pretty cool. And those are the triggers that, it kind of like fires 2 shots at once. That's not putting them out there. So Ahmad says, call them out in a video. I think I'm going to have to at some point because it's getting annoying. That's why they never made big magazines for the 1022 until after Bill died. Yeah. Once Bill Ruger died, Ruger kind of, as soon as Ruger died, Sturm Ruger changed his mind. Now they make AR-15s. They do whatever the fuck they want. It just took a while. What's wrong with PSA? They have quality control issues. But the problem is when you're trying to make it more affordable, quality control is an expense. ensuring you have proper materials, but then inspecting materials, that's time and money. So their quality control kind of goes a little, "Nyeh," but that also means their product output goes, "Nyeh," and that also keeps their price down. So it's that thing where you've got the three switches, fast, cheap, and quick, or cheap, fast, and whatever. You can only pick two. You can only pick two. Seller says, "Am I dumping the model stream?" I don't know yet because it's only midnight, guys. It's actually kind of late, and we might not do the model till tomorrow night, or we might do Sunday night. I'm not sure, but I'm not necessarily looking to do anything tonight with it. Yeah, if all you can afford is a PSA, get a PSA. PSA will work. It will work, and PSA is pretty good with their quality control now. Yeah, good, fast, and cheap. Yeah, there you go. Yeah, okay, there you go. The triangle is cost, quality, and quantity. Yes, and at best you can optimize two, but most of the time you get one. Yep. Kimbo says, "Please tip your YouTube host. It's tax-free, bish!" Teraba says, "The gun is better than no gun." Yeah, and that's the thing. PSA has done a great job at getting firearms out into the community. What they've done with the dagger, basically making third-generation Glock 19s. They're doing God's work out there, chat. It's just when they get into some things like the the MP5 and then their AK-74 platform, they just had some issues. But overall, it's not bad. Brimstone says Rock River Arms is decent quality. Yeah, but Rock River Arms, they're a little pricey nowadays. But I remember back in like 2007, Rock River was the hot shit. Those were the bee's knees of the AR-15 market. It's actually my first AR was a Rock River. It was an LAR-15. I still have it. Still my go-to. Michelle says, "I'm great for a couple days. My debit card got stolen." Oh no, that sucks. And Brimstone says, "Yes, it's here in the Quad Cities." Yep, in Kelowna, Illinois. In the Quad Cities. Downhill Defense is just down the road at Neosho. Nice. I thought they were in Kentucky. I didn't know they were in Missouri. What do I think of Ruger's Glock clone? I don't know. We'll have to see. I'm assuming like Glock has basically demonstrated what you have to do to make the gun work. So all the R&D has been taken out of it. So we'll see what happens. Lewis Machine and Tool is excellent. LMT is its own. They are on their own plane. LMT also makes 40mm launchers. So if you want an M203 LMT, LMT is never a bad choice. LMT is a little pricey, and back in the day, they were like the monolithic rail gang in town. So, yeah, LMT is good stuff. LMT is good stuff. LaRue is awesome as well. Yes, they are. LaRue is great. POF is great. Okay. Patriot Ordnance Factory. There's another POF. Pakistani Ordnance Factory. Not so much. So you got to be careful which POF. Patty's saying, "What is the battle rifle you would recommend that would also be reliable and shit? It's a fan." I mean, get a reputable AR-15 from a reputable, company. I mean, there's a lot of good reputable companies out there. Even a PSA AR-15 is going to work fine. A name says, again, they're doing with Glockwood, and now you can make your 19 to 17 without having to buy a new gun. Yeah, that's a separate thing. But Glock has done all the work now because the Glock 19's been around forever. It's basically you can copy it and they can't do anything about it. Terabus says you should still inspect your AR with gauges and whatnot when you buy it. It's not a bad idea throwing a go, no-go gauge in there. So, Axe says, "I like Bushmasters." Yeah, if you buy a Bushmaster, like an old school Bushmaster, a purple gripped one or a purple handguard one, those will be good. The purple ones are the best. Kimbo says High Point makes guns. Yeah, they do. High Point, if you need a $100 handgun, High Point's your thing. It'll work. Now, that said, the High Point carbines are fucking bomb-proof. They work forever. And for a long time, they were the only 10mm pistol caliber carbine you could buy. So as much as people like to shit on them, they filled a role. They filled a role. Let's see. Noveski also rocks out top notch. Yeah, but at that point, you're buying way more than you need. Like, if you want that quality, you can get that quality. But if you're looking for the basic level of quality, there's a lot you can do a lot more with less. And also for the amount of money you could spend on a Noveski, you could buy an AR-15. You could probably buy a fucking halfway decent red dot, a light and a sling for it, and you'll be better off than just having the Noveski. Steven says, I'm just out with a poverty pony lower. I need to build an upper 4 and a Wyndham A2 clone. Yeah, I need to do an A2 clone as well. I need to get like my Cold War vibe. That's the cool thing. The Cold War is now the retro scene for ARs. I just like the A2. It just fucking looks cool. The A2 series and like fixed carry handle ARs just look so cool now. So, huh. Let's see, what else are you guys talking about here? Let's see. I have an old Eagle Arms A2. Wow, that's a name I have not heard in a while. Amos says, I'll never not have a 20-inch barrel. Don't care what the normies use. Yeah, I need to get one, especially after you watch all the videos of like body armor penetrations and using a 20mm or 20-inch barrel. It's like zip with like M193. It's like a laser gun. Kia Patrick said the Marine Corps had a problem with the carry handles, like pockets in your pants. You were not allowed to use them. Wait, so if you had a carry handle and you carried your, like, most people never do it that way, but if you try to use the carry handle, you got in trouble for it. That sucks. That sucks. J Rock is, what did you see here? Say J Rock. Ag, hold on. What are you saying, Ag? Do a Mark 12 replica. That's another one I want to do. Like a Mark 12 with, like a Mark 12 Mod H with the PRI handguard, and you do the nice OpSync can on the front of it. That'd be pretty cool. That would be pretty cool. Kia Pat says, you'd be jumped by every NCO and higher if you use the carry handle. You lost your damn mind. Well, is that one of those times they'd be like, hey, devil dog, come here? And they just start hand knifing the shit out of you? That would suck. That would suck. It's interesting that, yes, in the Rhodesians cut the carry handles off their fowls because it was brass deflection issues. Yeah, my Mark 12-ish clone is built from parts from like 10 different companies. Well, that's how the Mark 12 is really built. It's got all kinds of parts. Like, it's got all different kinds of parts. That's kind of like how the Mark 12 was put together. So, Oh, Fallen Preacher is saying it was the same back in your Navy days at Great Lakes with the fake M16s. Couldn't hold them by the carry handle. That sucks. That's kind of like, I mean, I get it. Most of the time in boot camp, you're carrying it like on your shoulder, or you're doing drill and shit like that. But like, it's a fucking carry handle. That's what it's fucking for. Oh, at Fallen Preacher, they said this is the carry handle. Do not use it. Don't fucking use it. That sucks. That's funny. That's funny. Hodor says, that sounds rough losing an eye like that. Yeah, well, that's a problem with the foul carry handle. It could deflect brass right in your face. So, yes, it was originally a guard for the charging handle. Well, yes, because on the AR-15, initially it had a charging handle on top. It had this big hook. And if you guys go on Forgotten Weapons on YouTube, you can see how it would operate. If you carry weapons with the carry handle, you'll be wrecked. You know, I will, once I get my 727 clone built, I'll carry it by the carry handle just to piss you off, Patty. Oh. Let's see. You guys are so funny. All right, chat. Oh, let's see. Did I get everything? I think, oh, wait. John Coleman! John Coleman gifted 5 memberships, and then assholes react by puckering up. I mean, it's bad if the asshole reacts like, it should be like, ah! Because you don't want your asshole to react to go, ah! Just kind of thinking out loud here. They both gifted 5 subs. Praying the gray away, chat. Praying the gray away. Doing their part. They did their part, chat. J-Rock says, all night, Sean. Well, I don't know about that. Oh, Sergeant Dormant is going to LARP as a government-hating cowboy in RDR2. Cool. Cool. Kimbo says, what would you do in my situation? I don't know, Patty. You seem to be able to handle yourself pretty good there. Listen to your heart is what I would tell you. When those men in hoodies come up to you. Terabus says, I was born gray. It's genetic. Oh. Can we not talk about assholes? Danny On did that today on stream. What the hell was she talking about? Patty says the Marine Corps does not explain why you do things. You just do them. Sleazy just gifted 20 subs. 20, chat. Let's go. Keeping it green in here. Oh. Thank you, Sleazy. Thank you for the support and your generosity. Okay. Danny was talking about marring assholes on YouTube. How would you mar an asshole? I don't get it. How would you mar an asshole? Making assholes or like marring them? Because like marring them, putting marks in the asshole, like that's why I'm a little confused. J-Rock. Oh, J-Rock. J-Rock coming in with 20 more right off the top rail. He's like, I can do it too. And he's like, really want to get rid of the Grays. He's like, it's Friday 13th over, Grays. Your day is done. He's like, this is a green weekend. Thank you, J-Rock, for the support. Hodor says, I could dodge these all day. Well, basically bleaching assholes. Oh, people do that. Yeah, they get the sunlight on their assholes, then they like suntan it. That's a thing. Ag gifted 10 subs. Thank you, Ag. Thank you for the support and the generosity. Grays, your time is numbered. Your time is numbered tonight, Grays. That's all I can tell you. Better watch yourself. Watch your ass. Amateur Iconoclast gifted 1 sub. Thank you for the support. Yamal saying, is it was sunlight? I thought it was chemicals. No, there was like a whole thing. I think it was like in the middle of COVID. People were like, they'd roll up on their back and they were like, suntanning their assholes. They were doing it. They sell anal bleaching kits. No, I get that. I get that. But there was a whole thing as like, suntanning your butthole. Like that was an actual thing for a while. You can Google it. Cedar Rose, don't be careful how you Google it, but you can Google it. Cedar Rose gifted 1 membership. Thank you, Cedar Rose. And then Stephen Cooper with 10 more subs. Thank you. That's like 20 for you tonight, too. Thank you, Stephen. So, hold on 1 second, chat. All right. 2020 was a low point for humanity. Yes, it was. Demon's Rat saying, I don't know what it is, but I don't receive gift memberships anymore. I don't need the option on my phone to enable gifts on this channel. Well, I'm sorry to hear that. Nearest is unlikely to ever get gifted one, even though it is open, because YouTube definitively marked my channel due to spicy comments on videos, so there'll always be grace. I know there will, but we're gonna do our part. We're gonna try. Eventually, you'll get converted. You will get transed. Yes. This is green country. Yamal gifted 5 subs as well. He's like, Grays need to keep moving. Yamal, thank you for the support and the generosity. Thank you. And yes, vitamin D for your asshole. Yes. Oh. Kimbo says, introducing more protein in my diet worked. I'm down 20 pounds after doing mass injections. Oh, I'm sure they were masked, all right. Make sure they weren't paused. That's the bigger thing. Make sure they're not paused. All right, chat. So, You guys are just gifting memberships to the Fed accounts. Oh, no, that would be horrible. I hope that's really not happening like that. All right. Yamal saying, is it inappropriate to ask for a good entry rifle recommendation? Well, I mean, like you're asking about like a gun. You're not asking like how big's your wiener. So no, it's not inappropriate. It's like, that's not a bad question to ask. What would be a good one? I mean, like really, like if you really just like want a basic thing you can have right now, get a PSA, Palmetto State Armory. Like it's gonna be cheap, it's gonna be affordable, and the bigger thing for you would be getting one and learning how to use one, shooting it, buying magazines, buying ammunition, buying a light and a sling and a red dot or a hollow sight. Those are very important things, and for like $500-600, that's not a bad idea. And that would allow you to do more. So that would be my recommendation. That would be my recommendation to you. And that's how I would want to do it if I were you. So that's how I would do it. I mean, like I said, you don't have to buy an expensive one. You don't have to buy an expensive thing. 40-round mag and an 11.5 with a suppressor. Yeah. Okay. No, I would not recommend that as a beginner gun. But really, Yamal, that's what I would tell you is get something like that. It's called Palmetto State Armory. They're out of South Carolina. I mean, or you could find do not buy secondhand, don't buy used, but go to a gun store. You could find an AR-15 for like pretty cheap. Like that's where I'd start if I were you. That's where I'd start if I were you. Don't make a pipe shotgun. That's a little out there past what you're doing. Kimbo says, what charges are they going to indict the UNC killer with? It sounds like second-degree murder. Yamal says, is the AR too complex for a new person? No. The military teaches everything to people at an 8th grade level. The AR-15 is very simple. I mean, you can, like, high school kids can use it and shoot up a school. No, they're very simple to use. Just, do a little YouTubing around, like you'll figure out how to care for one, maintenance. Go to a range, meet people who are shooting guns, and like you can learn, make friends at the range, go to shooting matches. You'll learn how to take care of and, do all stuff. Just for that first gun, it's not a bad thing. It's not a bad place to start. Then from there, once you do really good with that, you could probably, I don't ever recommend selling guns, but if you need to, sell that one and then buy a better quality gun. And and this thing here, Colostomy Bag is saying, to an extent, I agree with this. Don't be the guy that owns like 100 guns. The best thing to do is like get a rifle, get a really good rifle with really good gear on it, get a really good pistol with really good gear on it, and really like belt, holster, all that fun stuff. Then get like a precision rifle with really good gear on it, suppressors, all that fun stuff. That's more effective than buying 15 different guns. But a basic level first time buying an AR-15, a PSA is more than enough for you. And then from there, yes, once you understand it, you might be happy with that. But also you may be like, yeah, I don't want an AR-15. Don't sink a ton of money into something if you're not sure you want to do it. So ease into it, figure out what's good for you, and then go from there. That would be my recommendation. But yes, at the end of the day, when you start buying guns, buy for quality, and then later on, make a collection. But yes, an AR-15 is easy enough to use. And then J-Rock gifted 5 more subs. Let's go, chat. Let's go. Has Chick's been a member for 2 months. Says, go to a PC and get a membership if you have an iPhone. Yeah. But yes, an AR-15, they're silly easy to use. An AK-47 is the same way. An AK and an AR-15 are silly easy to use and work on. So, Name of some sort says, I feel personally attacked with that comment. So do I. I'm personally attacked by that. I have a bunch of cheaper guns that have been better off buying more quality myself. So, Poverty State Armory. Yeah, but they work. They work. They work. They work. And they're good enough. They're good enough for the purpose they fill, being at the entry level. For being at the entry level, they work very, very, very well. Okay. So, chat, I think we might go ahead and, I think we're going to go ahead and we'll do some model stuff tonight, actually. I think we're going to go tonight. We're going to go all night. We're going to go for a little while tonight. So I'm going to actually, here, give me a minute here. We're going to set up we'll go set up a model stream here. Give me like a minute. Cosmic Bag says, I'm in the same boat. Too many PSA and no Geisleys. Yeah. Nope, I'm in that boat too. I should be having a decent PRS rig, a good pistol. Like, you see those things, you're like, I'm that guy. And like, buying nods and having like armor and all that. And you're like, wait, I bought a shitload of guns and I have like a bunch of garbage guns. And it's like, instead of focusing and building up your tool set and then buying things later. It's like, yeah, I didn't learn that well enough early on in life. So don't worry, I'm guilty of it too. I am guilty of it too. I will always be guilty of it. All right. Let's see. Oh, no, that didn't. Oh, hold on here. Layer, flatten, file. Emails. I said this is a PNG. Yes. Okay. Okay. Yeah, or you learn as you go. Yes, I agree. You learn as you go. Tomorrow's the Army-Navy game. Oh, it is. I forgot about that. Daniel Penny will be there with Trump and Vance. Haschick is saying, yeah, so theoretically in a super chat of $10, there's a ripoff there. Yeah, that's the way how they do stuff. Let me see here. What are you guys talking about? Did you see the Instagram video I sent you on Twitter? Hold on here. Did you send me something? Let me see here. What is this? Is there any sound to this? Oh, there is. Oh, okay. Yeah. Oh, here. Can I show this, Charlie? Or are we going to get in trouble? Not YouTube appropriate? Okay. Then I won't do it. I won't do it then. And we're not going to do it. Okay. Charlie's like, no. He's like, no, don't do it. All right. So we'll hold off. We'll hold off on that. All right, chat. So we're going to hold on here. StreamYard. Boo, 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 boo. All right, chat. We're gonna set this for 12:20. We'll set this for 12:25. 12:30. I'll give this a minute or two so I can get set up. Hold on here. Hold on, chat. All right. Hold on, we're trying to get this sorted out here. Gosh, that's a problem with YouTube. It's hard to redirect stuff quickly. They don't have things set up. Okay. You make this way harder than it needs to be. Content. The only thing I do not like about YouTube Studio. All right, here. YouTube customization. Redirect. There we go. Okay, so the redirect's finally up. That took long enough. Gosh, it's so annoying. So annoying. Yeah, you asked for the link. Okay, yeah, I was watching that link. I'm like, yeah, we can't do that. We can't show that one. Oh boy. Oh boy. You guys are talking about felonies being a lifetime. Well, I mean, for example, preacher, in Ohio, a 5th-degree felony, your maximum prison term is 12 months in jail. 12 months, which is less than the ATF's definition or the Gun Control Act's definition of felon. So in Ohio, you could be a convicted felon and still federally own firearms. DF88 said, "What's a better lower you'd recommend getting?" I mean, like, there's a bunch of good lowers you could buy, but you could do a poverty pony from Anderson and you'll be okay. I mean, really. What are you trying to do with it is the other issue, but you don't need you don't have to have the absolute best. Like, you don't need a Hodge lower or something like that. So Yamali says, yeah, but isn't getting expunged easier after 7 years when it's off your record? I mean, it doesn't really go off your record. Like, your record, like your criminal record never goes away. Like, your driving record may fall off, But yes, the longer you wait after you've been convicted trying to get things expunged or sealed, it's always easier to show, look, I've been a good boy for this amount of time. So, all right. So you can be a felon in Ohio and get your ability to vote. No, because if you're on a felony, you lose your right to vote right off the bat, but you get it back pretty quick. So, all right, chat. Well, we're going to land the plane. Everybody here, thank you guys for all being here tonight. It says 172 people are watching on Twitter. Like, I know they're not. Those are all bots. But anyways, hi, Elon. And guys, I will see you guys later. And remember, until next time, just because you did it does not mean you're guilty. And kind of get the feeling that these California people are going to get screwed again by the 9th. Just saying. Sadly, probably true. So anyways, good night, chat. I'm going to redirect you guys over to the Miles stream. We'll start in a couple of minutes so I can get set up. And I'll see you guys in a minute. Bye, everybody.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney.